Supreme Court, that the Supreme Court, this is the day, this is the day that the Supreme Court, that the Supreme Court. So this is the day that the Supreme Court is going to respond to all the petitions and everything, the final day of judgment. Hopefully, today, we don't know how long this is going to take, guys. I'm so excited to be part of this live conversation and to be a part of this live session. I don't know how long it's going to take, but it doesn't matter how long it's going to take. I am here live and direct, and we are going to give you what you need to know. But as far as we know, right now, President Tinubu remains the president of Nigeria, and nobody can change it. It's a wonderful day, guys. And we are live and direct. Of course, this is the City Boy movement. Patriotic Nigerians, of course, we are patriotic Nigerians coming together for the first time in the history of the country. To support our president, our elected president, for the first time in history, and that is what we are doing, guys. So I'm happy to be here. I'm gonna be, broadcasting, of course. I mean, anything in the courts that I can lay my hands on, I'm gonna share it with us, and even as we discuss, because today is the day of discussion. I believe that the federal government, they are ready for the people that say they want to cause confusion in the country, because they say they want to scatter everything. Now wow, we are waiting for them. Oh, you understand me? So I salute you. I can see all of you guys. Remember, we are kings and queens, and we have overcome the world. That is why we have overcome the world. The city boy himself defeated all defeatables. You understand me? The city boy, our own president. For the first time, we can be proud that we have a president that is in charge. The president that is in charge. The boss is on the throne. You understand me? President Tinubu is in charge. In fact, I received one of the good news today that was it yesterday? The president signed into law the Electricity Act 2023. That was yesterday. You understand me? I'm so much happy to hear that the president is also listening and is taking actions to make sure that all these things are resolved. Some of you don't know about it because they have distracted you. As I'm talking to you, everybody, of course, President Buhari started it, of course, but yesterday, President Tinubu, Asiwaju Bola Ahmed Tinubu signed into law the Electricity Act 2023, which means everybody, the state governors have power to generate electricity. It was a very wonderful summit. It was a very wonderful conversation, guys, that we know is going to lead to something big. A lot of people are already saying congratulations to you as well. Michael Sunubi, I see you. Congratulations in advance to all Nigerians. Almighty God in control. Coco Silvanus is already angry with me. Coco Silvanus, take it easy. I am not the cause of your problem. I am not Obi. I am not. I am not the cause of your problem. I am not the one that says you should have good leaders, especially in the southeast. I don't know. I don't know. I don't know. I don't know. Some of them are already casting doubt among themselves because they know that they go nowhere. They know how it's going to be like, and some of them don't want to talk about it. I see you, Osai, Seriki. I see you. I salute you. Badmus, I see you. Thank you very much. Badmus Afiz, I see you. Femi Abayomi, I see you. Thank you very much. Ademola, I see you. Ujin, I see you. Thank you very much. Adekunle Omoshebi, thank you very much for joining us. Engineer Adebunola, Adebun, oh my God, sorry if I don't pronounce that name well. I salute you. Dayo, I see you. Kanu left ear. So somebody is answering Kanu left ear. It's not going to be easy. I see Wike. I see what's his name again? Kai. Is it Kanduje? That is Kanduje. Wait. Let me put what I'm seeing on the screen, guys. Don't mind me. These people. They don't try. Now, wow. If had it been they are fighting for something good, maybe by now they could have gotten it. But because they have been involving themselves in all kinds of criminality. Please press the like button. Press the like button. You can share the video. Press the like button. Thank you very much, so that other people will see it. I salute you guys. There are lots of good people in the Southeast which I've met, I've spoken with. They are my friends, and I love them. I love my people from the Southeast, but not these criminals. I'm going to make sure I call out all these criminals anywhere they are. Ayo, Edobo, I see you. Thank you very much. I salute you, Ayo. Adediji Demola, I see you. Thank you very much. He said, Isima, we need urgent attention on City Boys movement on Telegram. What is going on Telegram? Can you send me the message? Please, Adediji, can you send me the message? Let me find out what is going on there. I see you. Suleiman, I see you. Thank you very much, guys. We are doing it as we normally do it. We are live and direct. Today, it's not going to be easy. In fact, from the drama already going on, it's not going to be easy, guys. Hopefully, they are going to take 24 hours today to give their final judgment, Supreme Court. Oh, my God. I cannot wait. I cannot wait. I cannot wait for the final judgment of the Supreme Court today so that Nigeria can move forward. These people have caused a lot of distraction everywhere. We just want to move forward. We, the patriotic Nigerians, were interested in this country moving forward, not people distracting us. That is what we are interested in. You understand me? So, yeah. So that's what we are going to be doing today, guys. I see all of you. There's a lot of comments here. If I don't mention your name, definitely I'm going to mention your name. Kanu left here. I don't know if Kanu have left here. Somebody say Kanu left here. Hey, Kanu left here. Victor Obo, the mounted renewed hope loading. Ade Dinyi, right? Oh my God. Muju Bale de. If I don't pronounce it, don't be angry, be happy. Congratulations. Samuel, I see you. Thank you very much. Good day to you, Mr. Nsima. Thanks a lot for your excellent job. Thank you very much. I see you guys. Ugochukwu Ogafo. And you come listen. What did Ugochukwu say? Leave Ugochukwu. Leave the guy is angry with me. My brother, Obi will not be president. Finish. Forget. Wobiandu Takalas. Good morning. I see you. Thank you very much. Demola, I see you. Demola, please send me the message on WhatsApp now. Let us find out what's the problem. Oh, I salute you, Prince. Prince, I see you. The first son of Idu, I see you. Henry Okechukwu, I see you, Henry Okechukwu. Good morning, my brother. I salute you, Henry Okechukwu. What are your expectations today? What do you think is going to happen differently? My own concern is that, do you think the court, they are going to keep us for another 24 hours today? Remember last time it was like 12 hours, nearly 12 or more than. I can't even remember anymore. Isa Abe, thank you very much. Thank you very much. Someone said this is one Obi fraud, Obi criminal, IPOP nuisance. They are posting rubbish on the Telegram. Leave these people. Oluwa Sheyi, thank you very much. He said, please share. Yes, please. If you want to share that. Baba Rex say, who is winning today in court? Who is winning? We already have a winner, guys. We already have a winner. There's nobody winning than who has won already. Election happened at the polls. Finish. Taye Dauda, thank you very much. Oluwa Suyu, thank you very much. Addis Ababa, I see you. Good job, my brother. Ayo Atemunu, say more power to your able. We shall rejoice at the end of the judgment. Bless you in Jesus' name. Thank you very much. I salute you. Olabisi Omala just say, my son, you have been a strong and reliable ally. We shall overcome in Jesus' name. Oh my God, thank you very much. We're already kings and queens and we overcome the world. That is the reality. Don't allow anybody to. There's nothing else that is happening than that. We are always winning. I can assure you, man. We are on the path of success and we are victorious. We are kings and queens and we overcome the world. Are you getting me now? That is why they are panicking. Okay, all of them are panicking with their lies and propaganda. They say that they after the judgment today that they want to scatter everywhere. Are you not aware? That is what they said. They say they want to scatter everywhere. Many have you not seen it? That is what they say. Oh, they say after the judgment they will start causing problems, especially from the this thing. They are training what they call it. They are training boys. They say they are training Biafra liberation people so that they will go and scatter. They will scatter everywhere. So I don't know. We are just waiting for them to scatter everywhere, as they say, that they want to scatter everywhere. If they no scatter, shame on them. If you are not scatter everywhere, shame on all of you. You understand?
Strict privacy laws in the jurisdiction of the Chicago State University. The request for the release of the academic records and certificates issued to the second respondent could not be granted without an order of court and for the purpose of use in pending court proceedings. The first applicant, through his said US.
So guys, I think they have started, so we are just going to be listening. We are just going to be listening to what they are going to be saying, definitely. Addis Ababa say, as acts from today, Nigeria will enjoy the work to is doing. Okay, Patrick Anyan say Atiku and Obi are bad Jews. They will fall and fail again. Victor Obo say whether the obedient and obituaries like it or not, Nigeria is moving forward. Anthony Oyewole say, I greet you, brother. Thank you very much. Okay, Chuku Bodo say patriotic fool. All right, guys. Ola Lekon Yomi say, God bless you, my brother. We are winning today, no doubt about it. Thanks. Yahuda say, alas, both Atikulus and Obingo have been put to shame. They need to beg Mr. President Bola Ahmed Tinubu, GCFR, for him to forgive their overzealous in wanting to become the president. We cannot forget criminals. We cannot forgive criminals. Criminals have to be punished. Even if we forgive, but there must be punishment. Oluwa Sheyi say, we need to be happy today. Emeka Samuel say, you be fool if you know. Emeka, I be fool, oh, wise fool that have defeated a smart idiot or smart wise. Kenny Ademosu say, good morning, my brother. Thanks so much. God bless you. Yakubu Aboki say, I dey always feel your temperature and the Obidirin are scared to the next level. Yes, I salute you guys. Guys, let me know what you think, what is going to happen today. Let's find out what is going to happen today. They are just starting, of course, they're just starting to read some things. But I just want to see your comments so that we are going to be listening together. Ugochukwu Okafor say, no, Nsiman, no. Coco Sylvester called you Mumu, and I said to him, come listen. Okay, Ugochukwu, thank you very much. No problem, I understand. And Nissan say, thanks for the update. Osai say, God don't start to take it easy, my brother. This country, you don't go easy to do. So just take it easy. Erika say, well done. Aziz said they will soon collect useless people, Almighty God on our side. Ugochukwu say, I dey fight the bingos. I see you, Ugochukwu Okafor. Thank you very much. Joago Vincent say, an idiotic animal. Are you back today? How Adediji say, how can someone claim what he never earned from the majority? He should go and be Anambra fraud president. My brother, election is won at the polls, not in the Supreme Court. It's very simple. Military are waiting for them on the street. Yes, they should be ready. Suleiman say, up Jagaban. Okay, let's just listen to what they are saying now as we continue reading. Please, I need your comment on this.
And that whoever issued the certificate presented by the second respondent did not have the authority of the Chicago State University, and that second respondent never applied for any replacement certificate, nor was he issued any, replacement certificate by Chicago State University. The deposition which is on oath, that is number 14th ground. The deposition which is on oath deposed to in the presence of the second respondent's attorney is credible and believable and ought to be believed. 15. The deposition is clear and unambiguous, and no further evidence is needed to be adduced on it. 16. The evidence is such that could not have been obtained with reasonable diligence for use at the trial, as the deposition required the commencement of the suit in the United States of America before receiving same. It was not possible to obtain the said evidence before the trial at the court below. 17. The deposition was made on October 3, after the conclusion of trial at the court below, and was not available to be tendered at the trial court. 18. Presentation of a forged certificate to the INEC by a candidate for election to the office of President of the Federal Republic of Nigeria is a weighty constitutional matter requiring consideration by the court as custodians of the Constitution. 19. The original certified deposition has been forwarded to the Honorable Court by a letter addressed to the Chief Registrar of the Supreme Court. And 20, the last, it is in the interest of justice for this Honorable Court to exercise its discretion in favor of the appellant applicants. In support of the said application is a 20-paragraph affidavit deposed to by Uyigiwa Osage, Nigerian citizen, a legal practitioner, and legal advisor to the first appellant, with exhibits A to H annexed. Learned Senior Counsel for the appellant applicants, Chief Chris Uche, SAN, leading other senior and other counsel, filed a written address in support of the motion. Upon receipt of the said motion on notice, the first respondent filed an 11-paragraph counter affidavit deposed by one gift.
So guys, they are reading it, and you can listen to it. The people that are countering the affidavit or writing appeal or whatever, all of them, they are Biafra. They are Biafra. They are Biafra. They are Biafra. They are the bingos. Are you getting me now? So we are going to be listening, even as the judge is just reading all those things. That's it. What they say, why, whatever. So let's just listen. I'm going to be here. I'm going to be reading your comment as well. What do you think is going to happen today? Do you think that the Supreme Court will take time just like the appeal court? Please, I want to know. Thank you.
On 12 October 2023, annexed to the counter affidavit are exhibits 1 to 9. And in support of the counter affidavit and in opposition to the motion, Learned Senior Counsel for the second respondent, Chief Wole Olanipekun SAN, leading senior counsel and leading other counsel, filed a written address on the same date the counter affidavit was filed. The third respondent's counter affidavit was deposed to by one Peter Emma Iko, a legal executive in the law firm of Olujinmi and Akeredolu, lead counsel for the third respondent. The 9 paragraphs counter affidavit is supported by a written address, filed and signed by Chief Akin Olujinmi SAN. Upon receipt of the various counter affidavits, the appellants filed a further affidavit of 20 paragraphs deposed to by the same Uyigiwa Osage, with 12 exhibits further annexed. Learned Senior Counsel also filed reply on points of law to the written addresses filed by the first, second, and third respondents in their opposition to the applicant's motion on notice for fresh evidence and/or additional evidence. At the hearing of this motion, both the applicants and the respondents adopted their supporting and counter affidavits respectively. They also adopted and relied on their various written addresses. In the applicant's written address, the Learned Senior Counsel submitted one issue for determination, to wit, whether this honorable court ought to exercise its discretion in favor of the appellant applicants by granting the prayers sought. The first respondent's senior counsel also donated a sole issue for determination as follows: whether, in view of the peculiar facts of this case, this honorable court can proceed to grant the instant application. For the second respondent, Chief Olanikbeku, SAN, submitted one issue, which states, considering the background of this case, as well as the applicable constitutional and statutory provisions relevant to election appeals and proceedings, whether this honorable court will grant this application. Finally, Chief Akin Olujinmi, SAN, leading other counsel for the third respondent, opined that the crucial question to be addressed in this motion is whether this court has jurisdiction to entertain this application. Now, taking a clinical look at the four issues, it is crystal clear that they all say the same thing. And put in simple terms, it is whether the law of Nigeria, as presently constituted, allows this court to receive the evidence in question and act on it at this stage. In his argument, the learned senior counsel for the appellants submitted that this court has the power, the jurisdiction, and the discretion to grant an application to adduce fresh and or additional evidence on appeal, referring to Order 2, Rule 12.1 and 2, and Rules 12.1, 2, and 3 of the Supreme Court Rules, and the case of Uzodinma and Izunaso, citation supplied, learned senior counsel submitted that the grant of this application will be in furtherance of the cause of justice. That this is a case in which the second respondent was purportedly declared as the winner of the election to the office of President of the Federal Republic of Nigeria, and the appellant applicants have, amongst other grounds, challenged the election of the second respondent on the ground that the second respondent presented a forged document to the Independent National Electoral Commission. That the appellants have also a challenge in their appeal, the striking out of their pleadings raising the issue of qualification of the second respondent to contest the said election. Learned Silk also relied on the cases of Nigerian Customs Service Board and Innocent and other cases cited in this judgment. According to the Learned Silk, the evidence required to establish that the certificate presented by the second respondent to the first respondent in support of his qualification to contest the said election is the deposition from the Chicago State University, which deposition did not become available until after the determination of the case by the lower court. He contended that the appellant applicants have successfully explained the delay and difficulties in obtaining the said evidence earlier than now. Relying on Saleh and Abba citations supplied, the learned senior counsel urged this court to resolve the sole issue in favor of the appellants and grant the application. In response to the above argument, the learned senior counsel for the first respondent, A.B. Mahmoud S.A., submitted and urged this court to dismiss the appellant's application as they have failed to meet the conditions for grant of same. He opined that election petitions are sui generis, and as such, this court, in determining this application, must take into consideration the peculiarity of the instant appeal, which is an appeal against the judgment of the Court of Appeal, sitting as the Presidential Election Petition Court, and based on the provisions of the Constitution of the Federal Republic of Nigeria 1999 as amended, and the Electoral Act 2022. He stated the three conditions that has to be met before the fresh evidence can be admitted, and he urged this court to hold that the appellant applicants failed to fulfill the conditions. In this, he relies on the case of Adeleke and Aserifa, Wata and Anyago. UBA PLC, and BTL Industries, all citations supplied, amongst others. It is his contention that the appellants were tardy and were not reasonably diligent in their attempt at obtaining the documents which they seek to be received in these proceedings, that having not acted with reasonable diligence, this court ought not to grant the instant application, also relying on Obi and Atiku as limited. Learned Senior Counsel also drew the attention of this court to the decision of the court below, which has not been appealed against, that the petition did not plead facts in support of non-qualification or disqualification of the second respondent in their petition, and that their efforts to remedy it through their replies to respondents' replies were belated and were rightly refused. According to him, the deposition of Caleb Westberg is irrelevant since the appellants did not raise the issue of forgery at the lower court. And relying on the case of Okwe Kenya and registered trustees of Jude Anglican Church, citation supplied is submitted that evidence not supported by pleadings goes to no issue. Learned Silk further submitted that insofar as the deposition of Caleb Westberg is solely to disdain the certificate presented by the second respondent and attached to his form EC9 dated 17 June 2022, which the first respondent published as far back as 24th day of June 2022, the appellant's complaint in that regard is pre-election matter, which by section 285(9) of the Constitution of the Federal Republic of Nigeria is statute barred. As such, an action ought to have been initiated within 14 days of the second respondent's submission of his form EC9 or the publication by the first respondent. He urged the court to so hold. According to Learned Senior Counsel, an allegation of presentation of false or fake certificate is rooted in the criminal offense of forgery, which requires proof beyond reasonable doubt. He contended that the deposition by Caleb Westberg, which seeks to establish a case of forgery against the second respondents without more, cannot ground the conviction for forgery of as proof beyond reasonable doubt cannot be solely based on an affidavit evidence, relying on Abubakar and INEC, Agi and PDP, Mohammed and Wamako, all citations supplied. Learned Silk argued further that the deposition of Caleb Westberg alone does not, under our law, constitute credible evidence to establish a case of forgery. Finally, the Learned Silk submitted that this appeal, being based on an election matter, where a trial court is to hear matters and deliver judgment not later than 180 days after the filing of the petition, the implication is that all evidence
dimmer switches guaranteed, plumbing guaranteed.
Sorry guys,
tiling,
that is
guaranteed.
Tradespeople so good, guarantee their work free.
It's advert. So guys, that was advert though. That is not the court though. It's advert on their page. The page has
jurisdiction over the
Let's
matter.
go ahead.
He wondered what would happen now.
But
that
from
all
all indication, I think from what the judge is saying, it's not looking good. It's not looking good for Obi. I don't think it's gonna look good for Obi. It's not looking good. It's not looking good for Obi and Atiku. Somebody said, Aji Cap said, what's going on? I'm not hearing any noise on social media, my brother. There will be no noise. You know, so are you hearing what the Supreme Court, what they are saying? They are thinking there were even arguments if they even need to accept the case in the first place, you know, the appeal or whatever they are bringing. They are even it's not going to look good. Let's continue.
2023 in this court hall. That the lower court, having lost its jurisdiction since 17 September 2023, upon expiration of the 180 days from the date of filing the petition by the appellants, this court cannot grant this application. That section 22 and 23 of the Supreme Court Act give power to order two rule 12 rules of this court, and that lower court still has jurisdiction. Referring to Omubilari and Igbo Asoyi and others, and Adebite and Omosun, all citations supplied, the legislature contended that applicants failed to satisfy the 5 conditions enunciated in those cases before this type of application can be granted. According to the learned SAN, the failure of the applicants to have validly pleaded facts and documents sought to be received in evidence is fatal to this application, relying also in Obasi and Omuka, Start Oil, Nigeria Limited and Induction, and others, all citations supplied. Making reference to the USA Rules on Civil Procedure 32A1A, the legislature opined that the failure to invite the All Progressives Congress and the Independent National Electoral Commission to participate in the deposition made in the United States renders Exhibit C and D inadmissible. More so, since the alleged forged certificate is alleged to have been submitted to INEC. It is further contention that Exhibit C and D have no utility or affinity with this appeal, for the fact that there is no ground of appeal upon which they can be structured, as well as there being no accommodative issue for determination, relying on a number of cases listed in this judgment. Finally, Learned Senior Counsel submitted that Exhibit C, D, unpretentiously attempts to allege a criminal offense of forgery against the second respondent. You find that a criminal offense must be proved beyond reasonable doubt, as provided in Section 135 of the Evidence Act, also referring to the cases of ACN and Nyako and Kaki and PDP. He concluded that the Supreme Court does not have original jurisdiction to try the case of forgery. He urged this court to refuse this application and hold that it is an abuse of court process. For the third respondent, Chief Akin Olujimi SN made submissions which are similar to those by the learned counsel for the first and second respondents. With due respect to the learned Chief Silk, I shall refer to them in the process of resolving the sole issue in this application. In the applicant's reply on points of law, learned senior counsel listed some paragraphs of counter affidavit of the second respondent, which he alleges consists of legal arguments, objections, and conclusions, which he urged that they be struck out. On issue of jurisdiction, he submitted that Section 285(6) of the Constitution, which pegs 180 days for the hearing and determination of the election petitions, does not include the Court of Appeal, but only election tribunals. Learned Silk submitted that issue of qualification is for both pre- and post-election matters, referring to Section 137(1)(j) of the Constitution. He urged the court to grant this application in the interest of justice, as was done in Amechi and INEC and Obi and INEC, all citations supplied.
Guys, it's not looking good. It's not looking good.
In resolving the sole issue submitted for the determination of this motion,
certificate or no certificate has no
I wish to start from the beginning.
What they are doing. There is no.
And the beginning is the issue of jurisdiction. Whereas the respondents in their various written addresses have urged this court to grant have urged this court not to grant this application as it is an exercise in futility. They opine that the Supreme Court does not have jurisdiction to look into or act on Exhibit C and D if admitted into the proceedings. The learned senior counsel for the appellants submitted otherwise. I have already summarized their various positions and I shall refer to them as we proceed. It is elementary to state that the judicial court is the authority which a court possesses to decide matters brought before it, or to take cognizance of matters presented in a formal way for its decision. In an old case of Ogun Makun and Milad Osun State, citation supplied, this court stated as follows: jurisdiction of the court is the basis, the foundation, and the live wire of access to court in adjudication under Nigerian civil process. As courts are set up under the Constitution, decrees, acts, laws, and edicts, they cloak the courts with the powers and jurisdiction of adjudication. If the Constitution, decrees, acts, laws, and edicts do not grant jurisdiction to it or tribunal, the court and the parties cannot, by agreement, end jurisdiction, as no matter how well intentioned and properly conducted the proceeding, once it is competent, it is a nullity and an exercise in futility. End of quote. The jurisdiction of the court has further been defined as the very fundamental and priceless commodity in the judicial process. That is to say, it is the fulcrum, the centerpiece, or the main upon which the validity of any decision of any court stands and around which other issues rotate. Thus, cannot be assumed or implied. It cannot also be conferred by a party or by consent or acquiescence of parties. A lot of cases have been cited to support this. This and that is the general nature of jurisdiction. I must emphasize that the matter under which the application is brought is an appeal in an election petition. It is tried that election petition proceedings are sui generis. It has its own set of laws and rules which a court must recognize and enforce. See Buhari and Yusuf, Egbarioba and Erobo, all citations supplied. In the circumstance of this case, this court, in determining this motion, has to take into consideration the peculiarity of the instant appeal, which is an appeal against the judgment of the Court of Appeal, sitting as the Presidential Election Petition Court, based on the provisions of the Constitution of the Federal Republic of Nigeria and the Electoral Act 2022. I have carefully perused page 1 of volume 1 of the Record of Appeal, and it is very clear that the petition giving birth to this appeal, and particularly this application, was filed on the 21st of March 2023, which was the last day of the 21 days prescribed in Section 285, Sub 5 of the Constitution of the Federal Republic of Nigeria, 1999, as amended, for filing of election petitions after announcement of result of election. By sub-paragraph 6 thereof, an election tribunal shall deliver its judgment in writing within 180 days from the date of filing the petition, and where there is an appeal, it shall be determined within 60 days from the date of delivery of judgment of the tribunal or court of appeal. As pointed out by learned senior counsel for the respondents, the 180 days prescribed for the hearing of the petition by the Court of Appeal lapsed on the 17th of September 2023. In other words, the court below lost its jurisdiction to determine any matter in relation to the petition. This application before us relates to fresh evidence obtained after the judgment of the lower court and after the 21 days for filing election petition and after the expiration of the 180 days of the filing of the petition. What are the legal and or constitutional implications of the above scenario in relation to Exhibits A and D sought to be received into these proceedings? Several of the decisions of this court have taken care of the above scenario. One of the most recent cases decided by this court is the case of Towo, Womo, and Ajayi, the citation supplied there, wherein this court stated as follows, and I'll quote, "In the circumstance of this case, this court cannot activate Section 22 of the Supreme Court Act 2004, since the 180 days provided by the Constitution to determine the appellant's claim at the trial court has lapsed since 1st January 2023. The originating summons was filed on the 5th of July 2022 and expired on 1st January 2023 at the Federal High Court. This appeal was taken on 2nd January 2023, and there is no opportunity for the contentious issues of fact in the controversy in this appeal to be sent back to the trial court. The issue of the merit of the allegations of false information was not tried by the two lower courts and cannot be tried by this court pursuant to Section 22 of the Supreme Court Act. This court cannot do what the trial court is no longer constitutionally permitted to do by virtue of Section 285 of the Constitution of the Federal Republic of Nigeria, the Groundnum. See OK, Mimiku, C, APC, and Marafa, all citations supplied. As stated by the appellant applicants in the application, the reliefs they seek is an order of this court granting them leave to produce and for this court to receive fresh or additional evidence by way of deposition on oath. Clearly, the application runs foul of paragraphs 14 sub 2 and 16.1 of the first schedule to the Electoral Act, which inter alia outlaws any amendment of substance, as in this case, or introduction or addition of substance to the statement of facts relied on to support the ground of the petition after the expiration of 21 days prescribed in Section 132, sub 7 of the Electoral Act for the presentation of an election petition. There is no doubt that the deposition is one of substance, and that is in fact why the appellants are seeking to introduce it into this appeal. For the avoidance of doubt, I shall reproduce Section 14.2, paragraph 2A of the first schedule to the Electoral Act 2022 as follows.
It's not looking good for Obi. It's not looking good.
After the expiration of the time limited by A, Section 132(7) of this Act for presenting the election petition, no amendment shall be made. No amendment shall be made. 1. Introducing any of the requirements of paragraph 4.1 not contained in the original election petition filed. Or 2. Effecting a substantial alteration of the ground for or the prayer in the election petition. Or 3. Except anything which may be done under subparagraph 2A2 effecting a substantial alteration of or addition to the statement of facts relied on to support the ground for or sustain the prayer in the election petition. End of quote. Nothing can be clearer than the above provision, which clearly states that a petitioner shall not be permitted to amend his petition after 21 days allowed by Section 132 sub 7 of the Electoral Act. The applicants herein have not even applied to this court to amend their petition in order to reflect the fact of forgery, and Exhibit C and D sought to be admitted into the proceedings. Facts and documents which were not pleaded in the petition have no place in deciding the dispute between the parties. I still wonder how the appellants intend to use those documents in this appeal. Let me consider an unusual submission of the learned senior counsel for the appellants applicants. It is in respect of section 285 sub 6 of the Constitution, which states, an election tribunal shall deliver its judgment in writing within 180 days from the date of filing the petition.
Obi is crying.
But on page 3, paragraph 2.5 of the appellant's reply on points of law, he argued as follows, quote, interestingly, and contrary to the avowed position of the respondents, we make bold to submit that there is no such constitutional limit of 180 days on the lower court to hear and determine a presidential election petition, such that can rob this court to exercise its jurisdiction in any manner whatsoever. While establishing the election tribunals to deal with election matters from houses of assembly, National Assembly and governorship elections, the Constitution gave jurisdiction to entertain disputes from presidential elections only to the Court of Appeal. Thereafter, the Constitution was intentional and deliberate in setting the 180 days limit only for elections tribunals and not for the Court of Appeal, end of quote. It is shocking to have the above argument in print. It could have passed for a friendly joke, but not for a serious matter like this in the apex court. It is even an unnecessary joke over a constitutional provision. After election petitions had suffered under the previous provisions, which allowed election petitions to be heard even until the respondent has completed his tenure, and the National Assembly dealt with the mischief by limiting the time which election petitions shall be determined, it is unfair to suggest that we go back to those dark days. My lords, there is nothing in section 285(6) of the Constitution to suggest that the Court of Appeal can hear presidential election petition without time limitation. The lower court is bound by the provision of section 285 sub 6 of the said Constitution when sitting to hear election petition, just as other election tribunals, as was rightly submitted by the learned senior counsel for the third respondent, Chief Akin Olujimi S.A., for which I wholly agree. The appellants knew they had to prove the allegation of non-qualification raised at paragraph 16D and 146 of their petition against the second respondent within the 180 days adjudication window provided in section 182 sub 8 of the Electoral Act 2022 for determination of petition by the lower court, which expired since 17 September 2023. The 180 days having expired, the lower court therefore no longer had jurisdiction to allow the deposition sought to be introduced into the trial of this petition. This is the law which at this stage is elementary. Consequently, since the lower court no longer has jurisdiction to entertain any such application, it follows ipso jure that this Supreme Court, also has no jurisdiction to allow the deposition to be used in this appeal. It is settled law that where the time for doing a thing is limited by the Constitution or statute, the court cannot extend the time. That was the decision of this court in Brigadier General Mohammed Boba Mawar and Admiral Morotala Nyako, where Onogan Jesse, as it then was, held as follows. Quote, it is settled law that the time fixed by the Constitution for the doing of anything cannot be extended. It is immutable. It is fixed like the Rock of Gibraltar. It cannot be extended, elongated, expanded, or stretched beyond what it states. See also Abubakar and NASAM, all citations supplied. It has to be noted, as I stated earlier in this ruling, and for which there are several judicial decisions in this country, that the 180 days imposed on election tribunals and courts hearing election petitions is immutable and cannot be extended. The applicants have not even applied for extension of time to bring in the said depositions or extension of time to amend their petitions. Let me say it clearly that 21 days provided for the filing of petitions having long expired, even if the appellants had applied for extension of time to amend their petition in order to bring in the depositions, it would not have been granted based on the provisions of the Constitution and the Electoral Act. This principle was again restated by yet again on organ JSA as it was in NNPP and GONI. Citations supplied when he said, despite the decision of this court since October 2011 on the time fixed in the Constitution, some of the justices of the court still appear not to have gotten the message. From where will the election tribunal get the jurisdiction to entertain the retrial after expiration of the 180 days assigned by the Constitution? The answer is obviously in the negative. It should be constantly kept in mind that prior to the provisions of Section 285(6) of the 1999 Constitution as amended, there was no time limit for the hearing and determination of election petition by the election tribunals or the appeals arising therefrom. That situation resulted in undue delay in the hearing and determination of an election petition by the election tribunals or appeals arising therefrom. The amendment to the original Section 285 of the 1999 Constitution by allotting time within which to hear and determine election petition and appeals arising therefrom is designed to ensure expeditious hearing and conclusion of election matters. If the decision of the lower court is allowed to stand as urged by the respondents, it will reintroduce the earlier mischief which the amendment sought to correct. End of quote. See also Uba and Suswan. Citation supplied. The above statement by this court is very explicit, clear, and simple. As it is, the provision of the Constitution has spoken. There cannot be an addendum or another reopening of the case at the lower court, its jurisdiction having lapsed. My noble lords, I've taken time to state the law on the issue to show the futility of this motion. It cannot be granted. The jurisdiction of this court is donated by the Constitution and the Electoral Act regarding election petition appeals. We do not have the virus to admit this disposition, and we cannot invoke Section 22 of the Supreme Court Act, since the lower court has since lost its jurisdiction. More so, there is no paragraph of the petition to accommodate a case of forgery. Again, the appellants have distilled 7 issues for the determination of this appeal, and none relates to certificate forgery. One wonders what the appellants intended to do with the deposition, since appeals are heard on the issues distilled for determination by the parties in this court. In Saliba and Jackson, 2002, for Nigeria will report, citations others supplied. This court stated clearly that all appeals are decided upon the issues formulated for determination. What this means is that any matter not covered by any issue for determination is of no moment. Should the deposition be admitted, it will float in the appeal, as this court cannot exercise original jurisdiction even if we are to start a new case for the appellants. See Sanusi and Ayula, Gtex Industries, and Oceanic Bank, citations supplied. Finally, my noble lords, on this application, I wish to state that fresh evidence is not received as a matter of course. There are conditions which must coexist before the court can grant this type of application, as can be garnered from the decided authorities of this court, which include, but not limited to, Onwu Buariri and others, and Igbo Oyosi and others, Supra. A deputy and a motion are cases cited by the Senior Counsel by the second respondent. Simply put,
Obi Alpha, Obi.
The conditions for the grant of this type of application are that one, the
Alpha.
fresh evidence could not have been obtained with reasonable diligence at the trial. 2, such evidence, if admitted, would have important effect on the subject of the appeal. 3, such evidence ex facie is apparently capable of being believed. 4, such evidence would have influenced the judgment of the lower court in favor of the appellants had it been available. And 5, and if such evidence is admitted, further evidences from the opposing party would not be needed. Taking the first condition, for example, the appellants failed to convince this court on why it waited until after the court below delivered judgment in the petition and lost the 180 days donated to it by the Constitution before bringing the said depositions sought to be admitted in this court. It has to be noted that appeals are a continuation of hearing of the matter in the lower court. As was pointed out by the learned Senior Counsel for the first respondent, A.B. Mahmoud Essay, the presidential election was conducted on the 25th of February 2023, and the first respondent declared the second respondent as winner of the election on 1st March 2023. Thereafter, the appellants filed their petition at the registry of the court below on 21st March 2023. If I may ask, what attempts did the appellants make between the publication of the second respondent's Form EC9 and accompanying documents in June 2022, more than a year ago, and the date of filing the petition on 21st of March 2023 to obtain the documents from Chicago State University, which could have been used at the trial court? Again, what attempts did the appellants make to obtain these documents between the date of filing the petition and the conclusion of trial? To say the least, the above questions are critical in the quest of this court's efforts to decide whether the new evidence sought to be adduced could have been obtained by the appellants with reasonable diligence for use at the trial. And with due respect to the appellants and their counsel, I think they were a bit tardy and were not reasonably diligent in their attempts at obtaining the documents which they seek to have this court seek in this appeal. In Adeleke Aserifa Supra, this court held that where the evidence is available and could with reasonable care and diligence be made available to the applicant at the time of the trial, as in this case, the court should refuse to exercise its discretion to receive such evidence. From all
sorry, guys, that is advert. I don't know anything about that one. Oh. That one is advert from the channel. So let's see. But it's not looking good for Obi. There is no hope. There is no hope, child. There is no hope for Obi, guys, as we are saying. Please, Obi, what will you do now? Are you going to bring your Biafra Liberation Army? Or is Biafra coming? I beg, all those obedient, is Obi coming? When is he coming? Because it's not looking good. I don't think Obi is coming. We know that Atiku is not coming. He never worried about if he's coming or not. So it's not looking good on you guys. Please, what will Obi do now? Will he go? What will Obi? Because Obi don't have any other place now. Obi used to stay in Lagos. So will Obi go back to Lagos, or Atiku? We know Atiku will go back to Dubai. Where will Obi go back to now? Did Obi lose in all these things? Obi did not lose. So what next for them? Because as we can see, it's not looking good. You know, everything they say there's no affinity, everything struck out, it don't scatter. We'll continue to the hearing.
Respondents submitted 6 issues. So we have stated all the 7 issues in the judgment. You will see them when you get copies. There is no doubt that all the issues submitted by all the parties are similar and any could be adopted for guidance. I propose, however, to determine this appeal based on the issues as formulated by the appellants. After all, it is their own appeal. Issue 1. The thrust of issue 1 is whether the lower court was right in refusing to hold that the failure of the first respondent to electronically transmit results from polling units nationwide for the collation of results introduced by the Electoral Act 2022 and specified in the regulations and guidelines for the conduct of elections 2022 and manual for election officials 2023 does not amount to compliance, which substantially affected the outcome of the election. Chief Krisuche, SA, Learned Senior Counsel for the appellants, submitted in the main that by virtue of Section 64, Sub 4 of the Electoral Act 2022,
Obi is going to the World Cup.
The collation officers and returning officers of the first respondent, including the national chairman of the first respondent, were under a statutory obligation towards mandatory verifications and confirmations at all stages required before the announcement of the results of the election. Learned Silk further contended that at the trial of the appellant's subpoenaed witnesses, several INEC presiding officers, including PW 12, 13, 14, 15, 16, 17, 18, 23, 24, and 25, who handled the BVAS machines at the polling units on the election day, who confirmed the non-transmission of results of the presidential election electronically from the BVAS, whereas the results for the National Assembly election held simultaneously were electronically transmitted without difficulty. That the appellant's witnesses gave evidence that the bypass of the use of the prescribed verification technology was nationwide, affecting the entire polling units and collation of results all over Nigeria, and substantially affected the outcome of the election. That the sole witness of the first respondent, Lawrence Biode, admitted under cross-examination that the deployment of the technology of BVAS and IREV was to guarantee the transparency of the electoral process and the integrity of the results, but claimed that there was a technical glitch that made the system fail to work on the election day, which technical glitch was not explained by the first respondent. The appellant contended that the failure to transmit the results electronically led to manipulation of the results in favor of the second respondent. Learned Silk then urged this court to depart from its previous decisions pursuant to Order 6 Rule 54 of the Supreme Court rules on the manner of proof of non-compliance with the provisions of the Electoral Act in the light of the novel provision in Section 132 of the Act and paragraph 46 of 4 of the first schedule to the Electoral Act. The learned SN submitted that the assurances given to the public by the first respondents as a public institution that results will be electronically transmitted was dashed. It is his contention that the election ought to be nullified by reason of the gross misrepresentation by the first respondent based on the doctrine of legitimate expectation as applied by this court in Stitch and AG Federation. Citation supplied. The learned Silk concluded on this issue that given the introduction of technology into the collation process by the new Electoral Act 2022, the judicial approach and the attitude must of necessity be different from the analog past. He then invites this court to depart from its decisions on mode of proof of non-compliance with the Electoral Act in election petitions, as was the case in Nyesom Wike and Peterside, Okereke and Umahi, Shinkafi and Yari, amongst others. He urged the court to resolve this issue in favor of the appellants. In response, the learned senior counsel for the first respondent, Abi Mahmoud Hussein, urged this court to decline the invitation to override its previous decisions on the manner or proof of non-compliance because such invitation is not usually taken lightly by this court. He contended that the conditions for such application does not exist in this appeal, relying on VP Industries Limited and Cocoa Industries Limited citation supplied. He contended that the appellant has not contended that the previous decisions sought to be departed from were given per incuriam or erroneous in law. On the argument that first respondent failed to electronically transmit results, he submitted that the only reference to electronic transmission of polling unit results appears in paragraph 38(1) of the guidelines published by INEC for the conduct of the election, wherein it provides that presiding officers shall electronically transmit or transfer results of the polling units directly to the collation system prescribed by the first respondent. That the use of the word "or" in the said paragraph 38(1) of the guidelines gives the presiding officer the discretion or option to either transmit electronically or transfer the result to the collation system prescribed by the first respondent. Learned Senior Counsel submitted that the main complaint of the appellants relates to the alleged failure to transmit the election result to the IRE portal for members of the public to view, and that this amounts to non-compliance. He submitted that the IRE portal is only a public viewing portal and not a collation portal, relying on Oyetola and INEC citations supplied. He urged the court to hold that the failure did not substantially affect the result of the election, which was properly collated and result announced. In his argument, Chief Olanik Bekunese, for the second respondent, submitted that by all extant relevant laws, INEC has the prerogative of determining the mode and manner for the transmission of election results, and that the lower court was perfectly right, and in order when it so held. He faulted the appellant's claim and basis of allegation of non-compliance with respect to the presidential election in focus on their claim that the results of the election results were not electronically transmitted to the IREC in real time, not that it was not transmitted at all, and that the first respondent did not ensure that the results were collated on the IREC. He also faulted the appellant's insistence that the results ought to have been collated electronically on the IREC, and that omitting to do this automatically nullified the result of the election. Referring to the case of Labour Party and INEC, suit number FHC ABS 145 2022, delivered on 23/1/2023 by Wit J of the Federal High Court, which decided that there is nothing in a combined reading of sections 47(2), 52, 65, and 62, 1 and 2 of the Electoral Act 2022, which suggests that INEC is mandated to only use an electronic means in collating or transferring of elections results. Rather, that INEC is at liberty to prescribe the manner in which election results will be transmitted. That by section 287(3) of the 1999 Constitution, all authorities and persons are bound to enforce the terms of the judgment until set aside by an appellate court. He submitted that all through the gamut of the Electoral Act, the appellants were unable to refer to the lower court a single provision which prescribed electronic collation of results or even electronic transmission of results, and that was why the court below held that the petitioners were unable to prove that the Electoral Act or guidelines made it mandatory for electronic collation system. He submitted further that the appellants failed to show that the results collated was different from the one they perceived belonged to them. Learned Silk submitted finally that the Electoral Act 2022, the INEC regulations and manual points irresistibly to a manual collation of results contrary to electronic collation touted by the appellants. The reason being that by paragraph 93 of the regulations, The only circumstance where electronic copy of results becomes relevant is where there is no hard copy of the result. Then the electronic copy can be resorted to during collation. Learned Counsel Olanik Bekun urged this court to resolve this issue against the appellants. In his submission, Chief Olujimi SN, for the third respondent, submitted that the appellants seem to have admitted their failure to prove allegation of non-compliance when they pleaded with this court to depart from the earliest established legal position that non-compliance be proved on polling unit basis. He submitted that there is nothing compelling presented by the appellants to warrant a departure from the established legal order, relying on Wike and Peter's side, Belgore and Ahmed citations supplied. He urged this court to decline the invitation. According to Learned Silk, any arguments for relaxing the established standard of proof of allegation of non-compliance must not be driven by sentiments and cavalier presentation of a case seeking to overturn the will of millions of the electorate in a presidential election. He contended that the appellants merely half-heartedly offered 27 witnesses, many of whom were incompetent witnesses, while purporting to prove allegation of non-compliance covering 176,000 polling units spread across the 36 states that make up the Federation of Nigeria. He argued that based on the inadequate evidence, the allegation of non-compliance must fail, relying on Buhari and Obasanjo, Atiku Abubakar and INEC, all citations supplied. He urged the court to resolve this issue against the appellants. In their reply brief, the Learned Senior Counsel for the appellants faulted the response of the respondents in relation to their call for this court to depart from its previous decision touching issue of non-compliance. According to him, his argument is based on the introduction of Section 65 and 6 and 187 of the Electoral Act 2022 and paragraph 46 of 4 of the first schedule to the Electoral Act, which provisions were not in the 2010 Electoral Act, that these new provisions deal with the new manner of transmission of results as contained in paragraph 38(1) and 2 of the Regulations and Guidelines for Conduct of Elections 2022 and the legislative intervention to reduce calling of numerous witnesses. This is what the court has to say. By Section 135, sub 1 of the Electoral Act 2022, an election shall not be liable to be invalidated by reason of non-compliance with the provisions of this Act if it appears to the election tribunal or court that the election was conducted substantially in compliance with the principles of the Act and that the non-compliance did not affect substantially the result of the election. From the provisions of the Act stated above, it is crystal clear that a petitioner seeking to nullify an election on the ground of non-compliance must not only lead evidence to prove the non-compliance, but must also show to the court how the non-compliance substantially affected the outcome of the election. A petitioner in this situation must therefore adopt a kind of double-barrel approach. You don't fire one barrel and leave the other intact. Both must be fired together at the same time. From the evidence as can be garnered from the record, the judgment of the court below and the arguments of both parties in this appeal, one thing is very clear, and that is the appellants abandoned the duty imposed on them to lead credible evidence to prove non-compliance, but relied solely on the failure of the first respondent to transmit results real-time to the IREF portal. According to the appellants, this was enough to nullify the election of the second respondent. What exactly is the IREF portal? The court below held that the IREF portal is not a collation system. This court in Oyetola and INEC made it clear that there is a difference between a collation system and the IREF portal, though both are part of the election process. Whereas the election system is made up of the centers where results are collected at various stages of the election, the INEC result viewing portal is to give the public the opportunity to view the polling unit results on the election day. What this means is that where the IREF portal fails, it does not stop the collation of results, which up to the last election was manually done. The failure or malfunctioning of the IREF deprives the public and even election administrators and monitors the opportunity of viewing the portal and comparing the result collected with the ones transmitted into the IREF. Truth must be told, the non-functioning of the IREF may also reduce confidence of the voting public in the electoral process. My lords, the Electoral Act empowers the first respondent to determine the electronic device to be used during election and their purpose. The lower court held that the IREF is not a collation system, and I agree. I refer to paragraph 93 of the first respondent's guidelines and regulations for election, which provides that, and I quote, where the INEC hard copy of collated results from the immediate lower level of collation does not exist, the collation officer shall use electronically transmitted results or results from the IREF portal to continue collation. When none of this exists, the collation officer shall ask for duplicate hard copies issued by the Commission to the following in the order below. 1. The Nigeria Police Force, and 2. Agents of political parties. End of quote. Paragraph 93 of the first respondent's guidelines and regulations reproduced above shows clearly that recourse to the electronically transmitted result for the purpose of collation will only arise where the hard copy of the result sheet does not exist. Given when the electronically transmitted result or the result on the IREF portal does not exist, the Commission will ask the copies handed over to the Nigeria Police or agents of political parties. The elaborate arrangement made by the first respondent for collation of results is to make sure that at every point of collation, there is a result either from the hard copy with INEC or the electronically transmitted copy or the IREF portal copy or a hard copy given to the Nigeria Police, and finally, or a copy given to political parties. I think I can confidently say, and in agreement with the respondents, that the unavailability of the election result on the IREF portal, for whatever reason, cannot be a ground upon which an election could be nullified, particularly as it is not the case of the appellants that the hard copies of the result sheets did not exist at any level of collation. My Lord, having failed to prove its petition by conventional method known to this court, the appellants urge this court to depart from several decisions of this court on ways of proving non-compliance. They have not shown that those judgments were reached per incuriam or that there was any miscarriage of justice. See some cases cited. Section 137 of the Electoral Act relied upon by the appellants for their failure to prove non-compliance in the manner we are used to provide, and I quote, "It shall not be necessary for a party who alleges non-compliance with the conduct of elections to call oral evidence if originals or certified true copies manifestly disclose the non-compliance, end of quote. The above provision has not absolved a petitioner of the need to lead credible evidence to prove non-compliance. It states clearly that oral evidence may not be necessary if and only if originals or certified true copies manifestly disclose non-compliance. In this case, the appellants have not demonstrated the originals or certified true copies of documents they want the court to rely on. Given where such documents are tendered in evidence, it is to be sure that they manifestly disclose the non-compliance. On the whole, it is my well-considered opinion, which accords with the views of this court, but the court below, that the failure to transmit result to the IREB did not affect the result of the election. Accordingly, this issue is resolved against the appellants. The second issue is whether the court below was right in its interpretation of the provisions of Section 134 sub 2b and Section 299 of the Constitution of the Federal Republic of Nigeria as amended, in holding that securing 1/4 of the total votes cast in the Federal Capital Territory, Abuja, is not a constitutional requirement for the valid return of a candidate as duly elected President of the Federal Republic of Nigeria. In his argument, the learned senior counsel for the appellants urged this court to interpret the word "and" in Section 134 2b of the Constitution conjunctively and not disjunctively, which will make it compulsory for a candidate to score a quarter or 25% of votes cast in the Federal Capital Territory before he can be President of the Federal Republic of Nigeria. The respondents argue otherwise. My noble lords, on pages 8234 to 8235 of Volume 10 of the Record of Appeal, the lower court made the following decision, and I quote, "As expressly stated in Section 299 of the Constitution for the purposes of fulfilling the requirements of Section 134 sub 2b of the Constitution for the return of a presidential candidate as duly elected, the Federal Capital Territory, Abuja, is to be treated as one of the states in the calculation of 2/3 of the states, such that if the candidate polls 25% or 1/4 of votes in 2/3 of 37 states of the Federation, FCT inclusive, the presidential candidate shall be deemed to have been duly elected, even if he fails to secure 25% of the votes cast in the Federal Capital Territory."
Somebody say, Atiku and Obi are messing up with their political baba.
End of quote.
They will learn. They will learn. Don't worry.
To be very honest,
They will learn.
I do not see anything wrong with the above
They will
decision.
learn.
It is basic that one of the vital concerns of interpretation of statutes is that a court of record should be minded to make broad interpretation, or what is sometimes referred to as giving some a liberal approach. A court should give a holistic interpretation to a statute or the Constitution as required by law. Probably I may add that a court must give the Constitution or a statute a purposeful and people-oriented interpretation. What I'm trying to say is that in interpreting the Constitution, or any statute for that matter, a narrow and selfish approach should be avoided. The duty of the court in interpreting statute should be in such a way that it serves the generality of the people and not for a select few. It is tried that the legislature does not intend creating injustice or an absurdity. Hence, the court must always adopt a construction or interpretation which will not reduce legislation to futility and absurdity. See Governor of Kwara State and Dada, citation supplied. Let me drive this matter home. The poster rendered by the learned senior counsel for the second respondent in their brief comes handy. Assuming that a candidate scores the highest number of votes in a presidential election and has 25% or 1/4 of votes in 30 out of 36 states and Abuja, but failed to secure 25% in the FCT, are we saying that he cannot be president? Is that what the Constitution intended? I don't think so. The court below made it very clear when it held that if the framers of the Constitution had wanted to make the scoring of 1/4 of votes cast in the Federal Capital Territory a specific requirement for the return of a presidential candidate, they would have made that intention plain by using words that clearly separate the scoring of 1/4 of votes in the Federal Capital Territory as a distinct requirement. End of quote. The above decision of the lower court is unassailable, and I have no difficulty in agreeing with it. I see no merit in this issue, and I resolve it against the appellants. Issue 3 calls on this court to interrogate the decision of the court below and answer the question whether the lower court was not in error to have expunged the witness statements on oath of appellant subpoenaed witnesses, namely PW 12, 13, 14, 15, 16, 17, 18, 21, 23, 24, 25, 26, and 27, and the exhibits tendered by them on the ground that the witnesses' statements on oath were not filed along with the petition, and that Order 3, Rule 2 and 3 of the Federal High Court Civil Procedure Rules 2019 is not applicable in election matters.
Hold on, guys. I don't know what is happening there. I don't know what are they here. Hold on. I don't know what in the play. Hold on. I don't know what in the play. Hold on.
It's in possession of an adversary. In line, the 3 senior counsel for the respondents in their various briefs submit in unison that the 21 days prescribed for filing the election petition cannot be extended under any guise, and that paragraph 45B of the first schedule to the Electoral Act cannot be enlarged to accommodate witnesses' statements on oath, which were not filed along with the petition. That having responded to the petition based on the facts and witnesses' statements front-loaded, their right to fair hearing will be trampled upon by allowing new evidence through those witnesses when they have no right to further reply. They urge the court to resolve this issue against the appellants. Let me reiterate the already tried position of the law that the election petition is sui generis. That is to say, it is in a class of its own. As was held by this court in Abubakar and Yaradua, this is no longer a moot point. It is different from a common law civil action. In Kalu and Uzo, citation supplied, this court stated clearly that the Electoral Act of whatever version, particularly that of 2022, contains mandatory provisions. Thus, election petitions have certain peculiar features which make them sui generis. They stand on their own and bound by their rules under the law. It was further held that defects or irregularities which in other proceedings are not sufficient to affect the validity of a claim are not so in an election petition. A slight default in compliance with a procedural step could result in fatal consequences for the petition. It has to be noted that rules governing civil proceedings are not the same which govern election proceedings, and where the Electoral Act requires recourse to civil procedure rules, it must be made subject to the provisions of the Acts. My noble lords, a combined reading of Section 285, sub 5 of the Constitution of the Federal Republic of Nigeria as amended, and paragraph 45 of the first schedule to the Electoral Act 2022 shows that the time limit for the filing of written statement on oath of witnesses, the election petition proceedings, is 21 days from the date of declaration of results. As was pointed out by counsel for the respondents, due to the sui generis nature of the election proceedings, amendment to the petition or calling of additional witnesses will not be entertained after the statutory time limit for the filing of petition has expired. Thus, a petitioner cannot present his case in bit, otherwise the respondent's right to fair hearing will be breached. This was the position of this court in OK and Mimico citations supplied. In his contributory judgment in the above case, Clark B.J.S. retired made the following decision, and I quote, by paragraph 4, sub 1 and 5 of the first schedule to the Electoral Act, a composite analysis of the contents of an election petition has been spelled out, and also a list of materials which must be accompanied. The use of the word shall in the subsections is very instructive. It is mandatory and conclusive. In other words, the provisions do not allow for additions, and hence the procedure adopted by the appellants in seeking for extension of time is nothing other than surreptitious attempts to amend the petition provided. What is more, via paragraph 14.2 of the first schedule to the Electoral Act, the appellants by section 134.1 of the Act had been totally foreclosed from any amendment, which was in fact the hidden agenda promoting the application. Further still, and on a critical perusal of the application, Relief 2 seeks leave to call additional witnesses, to wit AEO. It is pertinent to restate that at the close of pleadings, parties had submitted the list of witnesses who were to testify together with their deposition. The idea, purpose, and intention of the application is suggestive of nothing more than a clear confirmation seeking an order for an amendment as rightly and ingeniously thought out by the trial tribunal and also affirmed by the lower court. This will certainly violate the provisions of section 285 sub 5 of the Constitution and section 134 of the Electoral Act. End of quote. It has to be emphasized that the use of the word shall in paragraph 4.1 and 5 of the first schedule to the Electoral Act makes it mandatory and conclusive. The question may be asked, can a court extend time circumscribed by the Constitution for a party to do a thing he could not do before the expiration of the time? The obvious answer is no. Such provisions like section 85 sub 5 of the Constitution are mandatory, and any exercise of discretion by the court is without jurisdiction and therefore a nullity. In APC and Marafa, citations applied, this court held that applications for extension of time to call additional witnesses and to file additional witnesses' statements after the prescribed period for presenting election petition are not permitted because election matters are time-bound, and by reason of being sui generis, the procedure in handling them are stricter than ordinary civil matters. See also Ararume and INEC citations supplied. Then learned counsel for the appellants had argued that the law does not compel the impossibility and that subpoenaed witnesses should be allowed to testify. But as was argued by the learned senior counsel for the first respondent, A.B. Mahmoud S.N., subpoenas are not a tool with which to circumvent the provisions of the law. and the effect and purpose of Section 285, Sub 5 of the Constitution of the Federal Republic of Nigeria and Paragraph 4.5 of the First Schedule to the Electoral Act 2022. It is on this note that I quote that the decision of the court below to strike out the offending witness depositions cannot be faulted. I resolve this issue against the appellants. Issue 4 orbits around the evaluation of evidence of PW1, PW2, 3, 5, 7, and 22, who were the appellants' collation agents at the court below. The appellants are aggrieved by the verdict of the court that the evidence of these witnesses were hearsay, thus inadmissible under the rule of evidence. For the purpose of clarity, I shall herein reproduce, albeit extensively, the observation of the court below, which led to the verdicts complained about as follows. Quote, the petitioners, it must be underlined, pleaded in paragraph 4 of the petition that the petitioners had agents in all the polling units, ward collation centers, local government collation centers, and state collation centers in all the states of the Federation and the Federal Capital Territory, as well as the national collation centers. Of this crowd of agents, the petitioners did not call any of their agents at the polling units. The said agents at the polling units were the ones who were meant to sign and collect duplicate results in Form EC8A. The few agents called were state and national collation agents. Largely, their testimonies were hearsay. Let us now examine their evidence before the court. The PW1 is Captain Joe Agada, retired. His statement on oath is at pages 198 to 200 of the petition. He was the petitioner's collation agent for Kogi State. In paragraph 7, 8, and 11 of his statement, he deposed that from the analysis, he discovered various forms of non-compliance and corrupt practices such as suppression of votes, manipulation of the beavers machines, manipulation of accreditation, intimidation and harassment of voters, massive thumb printing of ballot papers, etc. This witness did not give particulars of these malpractices. There was no forensic report to support allegation of thumb printing at the polling units. In PDP and INEC citation supplied, this court, per agim JCA, as it was, held that it is only a polling unit agent or a person who was present at the polling unit during polls that can give admissible evidence of what transpired during the poll in that unit. See some cases cited there. In the instant case, PW1 was not a polling agent. He was a collation agent. When cross-examined, he said he would be wrong to say that he was present when all the ballot papers and boxes were manipulated, that he visited only 20 polling units out of the over 3,000 polling units in Kogi State. He admitted that his party had polling agents in all the polling units and that they were still alive. The PW2 is also a collation agent. His witness statement on oath is at pages 213 to 215 of the petition. His statement is similar to that of the PW1. He is Dr. Folarin Sunday Adekunle. He was the collation agent of the petitioner for Ogun State on the election day. Under cross-examination, he said he only visited 19 polling units out of the 5,040 of the polling units in Ogun State. PW3, PW4, 5, 6, 7, 8, 9, 10, 11 are all collation agents. The evidence of these witnesses centered around the events and the duties they carried out by the polling units agents of the petitioners, they agreed under cross-examination that the polling unit agents functioned very well in their units under our law. Specifically, in Section 43 of the Electoral Act 2022, polling agents are permitted to be appointed by political parties for each polling unit and collation center. The wisdom in this is for each of the political parties involved in an election to be represented by its own agents. The duties of an agent are to represent the interests of his or principal, having regard to the fact that no mortal can be in all the places at the same time. The law allows political parties to have their agents at all polling units and collation centers. It is therefore not anticipated by law for any political party to appoint an octopus agent with his tentacles in all the polling units and collation centers. This is humanly not practicable. When therefore evidence is required to prove what happened in any polling unit or collation center, it is only the agent who witnessed the anomaly or the malfeasance that can legally and credibly testify. It follows, therefore, that PW1, PW2, PW3, PW4, PW5, 6, 7, 8, 9, 10, 11, 19, 20, 22, who were state and national collation agents of the petitioners, can only testify of the events in their units or collation centers where they voted or acted as agents, and not all over the states of the Federation. The polling agents, as presented in this petition, it must be noted, are not shown to be experts. The issue of their analyzing results of the election at the ward, local government, state, and national level without calling polling unit agents who witness the real casting of votes and events at the voting units cannot therefore arise. They cannot validly testify as of non-compliance at the polling unit level. Their evidence can only count as to what they saw, not what they were told by their field agents. What they were told is hearsay evidence. Section 38 of the Evidence Act 2011 specifically states that hearsay evidence is not admissible except as provided for in the law. It follows that the evidence of the collation agent discussion of voting are inadmissible hearsay and are hereby discounted as end. Without reservation, I endorse the above statement of the lower court, which is consistent with plethora of decided cases on the subject. Buhari and Obasanjo, Ladoja and Jimobi, and others cited. From the evidence on record, it is indisputable that PW1, 2, 3, 5, and 7, who were the appellant state collation agents and national collation agents, were not present in all the polling units, which results they have disputed, which means that their evidence in respect of all the polling units, other than the ones that they were present, were clearly hearsay. They were most likely informed by the polling unit agents who were alive but failed to testify. I must say that the above statement of the lower court had nothing to do with the court's failure to ascribe probative value to documents put in evidence pursuant to Section 137 of the Electoral Act 2022 and paragraph 46(4) of the first schedule to the Electoral Act, as vehemently submitted by the appellants. Indeed, the point is instructive in view of the fact that the court had earlier on page 8,102 of the record rejected and overruled the third respondent's preliminary objection, seeking that documents tendered by the appellant be expunged for being dumped on the court. The finding of the lower court in discountenancing the evidence analysis of PW1, 2, 3, 5, and 7, same being based on hearsay, cannot be faulted. More so, the appellants have not presented any argument to warrant the interference of this court with the finding of the lower court. The issue, again, is resolved against the appellants. Issue number 5 is whether the lower court was not in error in striking out several paragraphs of the petition and the replies of the appellants on the ground of vagueness and lack of specificity and for being new issues, mere denials, or being repetitions. It's not looking good
for Obi and Atiku. Sorry.
Well, this issue relates to the ruling of the court below on the first respondent's preliminary objection, seeking an order of court striking out 31 paragraphs of the petition on the ground that they were vague, generic, imprecise, and lacking in specificity to elicit reply from it, and contrary to paragraph 4.1 of the first schedule to the Electoral Act 2022. The court, after scrutinizing each of those paragraphs in a well-considered ruling, struck out 10 paragraphs, namely 92, 95, 98, 121, 126, 129, 133, 143, 144, and 146 for being vague, imprecise, and lacking in particulars. For the purpose of clarity, the court held on page 8025 to 8026 of the record as follows. The sum total of all the foregoing is that while paragraph 129 and 133 of the petition are liable to be struck out for non-joinder of necessary parties, to which Messrs. Adejo and Governor Yahya Bello of Kogi State, accused in the petition of committing electoral malpractices, paragraph 92, 95, 98, 121, 126, 129, 133, 143, 144, and 146 are vague, imprecise, and lack of particulars, and so fall short of the requirements of paragraph 4(1)(b) of the first schedule to the Electoral Act 2022. They are therefore all others struck out. Paragraphs 93, 94, 96, 97, 99, 100, 101, 102, 104, 105, 108, 109, 110, 111, 112, 113, 14, 115, 116, 118, 119, 120, 122, 125, 130, 134, 138, 139, 140, 141, 42, 145, on the other hand, are in order and properly pleaded, end of quote. Picked by the above ruling, the appellants now seek the interference of this court on the ground that their vehemence were sufficiently detailed. They also question the decision of the court striking out their replies to the respondents' replies to the petition. For instance, as touching on the disqualification of the second respondent from contesting election for the office of president, which particulars were supplied in the appellant's reply. It is instructive to note that in paragraph 146 of the petition, the appellants simply averred that, quote, the second respondent was at the time of the election not qualified to contest the election, not having the constitutional threshold, end of quote. They did not supply the particulars of the threshold, which they perceived disqualified the second respondent from contesting the election, as enumerated in section 137 of the Constitution of the Federal Republic of Nigeria, 1999, as amended. Howbeit, in their reply, the appellant ruled out monstrous particulars of disqualification by reason of dual citizenship, allegation of being an ex-convict in a USA district court, having forfeited to the USA the sum of $460,000 in a drug-related case, Note that these particulars referred to as further details were brought in by the appellants at the time when the respondents had lost their right of reply, which in essence offends the cardinal principle of fair hearing expressed in the Latin maxim audi alteram partem, meaning let the other side be heard as well. Paragraph 4(1) of the first schedule to the Electoral Act 2022 provides that an election petition shall A, specify the parties interested in the petition, in the election petition. B, specify the right of the petitioner to present the election petition. 3, state the holding of the election, the scores of the candidates, and the person returned as the winner. And 4, state clearly the facts of the petition and the grounds on which the petition is based and the relief sought by the petitioner. It is clear beyond a peradventure that the requirements of the law is as provided above is that the petition must demonstrate with specificity the complaints of the petitioner and the relief sought from the court. It gives no room for vagueness and imprecision.
Sorry, guys. Sorry, guys. Let me read out this thing. Let me read the frustration out. This one make me to laugh. I'll put it on the screen. The brother say, this is from Donatus. You know, from the word Donatus, you know that these are bingos, the Afro criminals. He said, greatly unfortunate that based on what is coming out of the judgment of the Supreme Court, it's still the same story. God knows everything. Our hope is in God's hand. There is no hope in the judiciary anymore. Nigeria is completely finished because they did not make Obi, because the judgment is not in favor of Obi or Atiku. Is that what you're saying? So, their eyes on the open, they don't they cry. They cry and never start. No worry. You think say we go forget all the things we will do? There will be a fine on all of you. There must be a fine.
Of the first schedule to the Electoral Act 2022. The Act frowns at the introduction of new facts, grounds, or prayers tending to amend or add to the averments of the petition in the petitioner's reply. In fact, a petitioner is only required to file a reply in answer to new issues or facts which may be raised in the respondent's reply, which were not dealt with in the petition. This means that where there are no new issues or facts raised in the respondent's reply, there would be no need for the petitioner's reply. See Oni and Oyebanji, citation supplied. I have critically considered the arguments of parties contained in their respective briefs of argument vis-a-vis the record of appeal. The affected paragraphs of the petition relate to allegation of wrongful cancellation of polling unit results in various local governments in Sokoto State without particulars, manipulation of results in unspecified polling units in some local government areas of Kogi State, wrong results entered for the appellants in unspecified polling units in Borno State, criminal allegations against Honorable Adejo and Governor Yaya Bello without joining them as parties to the petition, open-ended allegation of disqualification against the second respondent, and tying critical allegations of corrupt practices in the election to a statistician report prepared by one Samuel Odutan, that's PW21, without serving the said report on the respondents along with the petition to enable them respond thereto. I am unable to agree with the appellant's argument that the lower court was wrong to have struck out the affected paragraphs for disclosing no particulars, together with some replies in the appellant's reply brief, which sought to bring in new evidence through the back door. I uphold the decision of the lower court, striking out the affected paragraphs and replies of the appellants for being vague, imprecise, lacking in particulars, and seeking to ambush the respondents via the petitioner's replies. The ruling of the lower court is unassailable, and this court will not interfere. This issue, again, is resolved against the petitioners. Issue 6 is whether the lower court was not in error in its evaluation of the evidence of the appellant witnesses on the burden of proof and clear admission against interest made by the first respondent. This issue turns on the averment of the first respondent in paragraph 8 of his reply to the appellant's petition, that the appellants in this case won the contested election in 21 states out of the 36 states of the Federation, namely Adamawa, Akwa Ibom, Bauchi, Bayelsa, Borno, Delta, Ekiti, Gombe, Jigawa, Kaduna, Katsina, Kebbi, Kogi, Kwara, Nasarawa, Niger, Osun, Sokoto, Taraba, Yobe, and Zamfara states. The appellants contend that such averment is tantamount to admission against interest by the first respondent. They therefore question the declarations to return of the second respondent as the winner of the said election. On its part, the first respondent contended that its said admission is of no consequence, having regard to the fact that the appellant scored 6,984,520 votes, as against the second respondent who scored 8,794,726 votes. That in determining the winner or loser in an election to the office of president, the number of states won by a candidate merit any consideration except in the context of geographical spread and ensuring compliance with the constitutional requirements. In its evaluation of evidence on the issue, the court below on page 8238 of the record had this to say, quote, "The table referred to by the petitioners is the table of results declared by the first respondent. There is no other set of results placed before this court by the petitioners to form the basis of our finding of fact as to whether the declared result is wrong or not. Success or failure in an election depends on figures, which is in turn dependent on votes garnered by each candidate. So, where the complaint in an election petition is that the candidate returned did not poll majority of the highest votes in the election to be returned, as contended here by the petitioners, not only must the figures disputed be pleaded, the figures of votes the petitioner perceives as correct figures of the election ought to and must be pleaded." The court went further to hold on page 284 of the record that, quote, "Section 134 sub 2 of the 1999 Constitution talks of the highest number of votes cast at the election if the contest was among more than two candidates, as in the instant case, not majority of votes cast as propounded by the petitioners. The first respondent was therefore right from the results declared by her, in the absence of any rival or alternative result placed before this court by the petitioners, that the second respondent, who scored 8,794,726 votes, as against 6,984,520 votes scored by the petitioners in the election, scored the highest number of lawful votes cast in the election," end of quote. The above statements, qua holding of the court, represent the correct position of the law, and I wholly endorse them. I have earlier in this judgment resolved the issue of electronic transmission of results, which is...
Hi, I'm Jay Hutton. You may recognize me from Tattoo Fixers or as the owner of Adrenaline
Sorry
Tattoo
guys,
Studio.
that one is advert.
As a tattoo artist, one of the most frequently asked questions
that one is advert. Let the advert finish. Okay, so some people are still talking story. My brother, calm down. I told you that Obi can never become the president. Obi can never win in any way. There is no evidence that Obi can win. More is Idris say, because I no believe say people like una say this like look like how your country is, check the dollar rate. Now so una other countries be. There is no other country that is talking about any other currency that is not their money. It is only in Nigeria I hear people talk about dollars and pounds. When you are a Nigerian and you are using naira, that shows that you are a beer fraud. You don't value who you are. You are not part of the country. So get out. We don't have anything to do with all of you. Obi is going nowhere. It's not looking good for Obi and Atiku. Please, and somebody said here in the comment section, which I like so much, somebody said that I think Atiku and Obi they should let me read properly. Oh God, I missed it. He said Atiku and Obi should hold their lawyers for not advising them, giving them the proper advice. For me, I just feel like even all these lawyers and all of them, maybe because of money, all of them, the NBA need to do something differently, because these people, for the kind of things they were saying, it does not mean that they know what they are doing. But I'm happy for today. Right, getting me? So we are waiting for their next step. Bunch of criminals, bingos, Biafra criminals. Let your Biafra come now.
Full votes scored in the election, other than the scores presented by the respondent, INEC, showing that the second respondent scored the highest number of votes. It is presumed correct. In the case of Abubakar and Yaradua, citations supplied, this court held that, and I quote, election results are presumed by law to be correct until the contrary is proved. It is, however, a rebuttable presumption. In other words, there is a rebuttable presumption that the result of any election declared by a returning officer is correct and authentic, and the burden is on the person who denies the correctness and authenticity of the return to rebut the presumption, end of quote. See also CPC and INEC, Buhari, Anjo, Hashidu, and Goje, all citations supplied. Following from the above, it is clear that the appellants, having not put forward their perceived rightful score to rebut the results put forward by the INEC, the law presumes the first respondent's version as correct. It would not matter whether the appellant can prove having won more states or if the first respondent admits that much. The figures before us shows that the second respondent won the highest number of votes and was accordingly returned elected. From
Sorry, I see Ijele. Ijele said something that got my attention. I need to show you. Look at what Ijele said. Ijele, I salute you wherever you are, Ijele. He said, the king of the game. He said, when the judges are quoting Yaraduas and Atiku Abubakar, the rest assured is over. Listen. He said, when the judges are quoting Yaradua versus Atiku Abubakar, the rest assured it is over. It don't finish long time ago. We don't really. It is over. It is over. It is over.
Right, in its use of disparaging words against the appellant in its judgment, evincing hostility and bias against the appellants, thereby violating their right to fair hearing and occasioning grave miscarriage of justice. I have read the judgment of the court below, and I've seen the context which those words were used, and it is my view that they were not meant to disparage the appellants or their counsel. As judges, we are trained to be temperate in our use of words, and we shall continue to do so. Litigants are advised to trust the court whenever their matters are before it. It is very unbecoming these days that while a matter is pending in court, litigants engage in press conferences, analyzing the case, reaching conclusions. Based on this, some of their followers send threatening messages to judges and justices. Matters in court are said to be sub judice, and as such, parties and probably the counsel should refrain from media trials and media judgments.
Oh my God! This is.
I need not say more on this.
This is very, very.
A word is enough for the wise.
Do you hear that?
This issue has nothing positive to offer the appellant. On the whole, having resolved all the issues against the appellants, it is my view that there is no merit in this appeal, and it is hereby dismissed. The judgment of the court below, delivered on the 6th of September 2023, affirming the election of the second respondent as the duly elected President of the Federal Republic of Nigeria, is hereby affirmed. I shall make no order as to costs. My learned brother on my right will deliver his judgment.
He said Obi and Atiku brothers should stop sending comments and threatening the judges. Oh my God, that this application will not have anything positive. That is, I hereby dismiss. I never know that they will make this kind of strong conclusion. This is so powerful. In fact, they have even concluded, even when other judges will speak, that will be the same. It doesn't matter what other judges are going to say. That is finished. It's a done deal.
Having had a preview of the judgment
Anyway,
of
let's
my
just listen
learned
to all of
brother,
them. My brother is, I think,
John
how many
Ian
judges? 5 judges.
Goro JSC,
My brother.
availed me with a copy of the said judgment just delivered in SC/CV/935/2023. Atiku Abubakar and the Independent National Electoral Commission and others. I completely agree with the critical analysis of both the oral and documentary evidence presented before us in this appeal.
Wow.
Therefore, I agree with my learned brother that the motion of the appellants filed on the 6th of October 2023 for leave to the appellants to adduce fresh or additional evidence is devoid of any merit.
Hey! Devoid
I also
of any
dismiss
merit.
the same.
Hey!
On the main appeal, my learned brother resolved all the issues, the 7 issues against the appellant. I therefore agree with him that the issues in the main appeal are devoid of merit, and the appeal is accordingly dismissed.
Oh my God, their battery don't go. Guys, let me connect to another platform. I don't know, their battery has gone. They are changing their battery, hopefully. But this is so powerful, guys. I don't want to miss that judge. Oh my God, I am so gingered. In fact, we are going to cut that section of that judgment. He said they should stop their stupid comments and making judgment on social media. Oh my God, this is so powerful, guys. Did you hear that? In fact, I never believed that this kind of final judgment will be. Oh my, that is the end of the issue. Oh, nah, if you see the thing scatter me. The thing scatter me. Ah, man, that I've not. This is so powerful. Congratulations to the City Boy family. Congratulations to the people of God. We're the real people of God here. I'm telling you guys, this is so powerful. Let me connect to another platform because I don't want to miss anything. I don't want to miss anything at all. So powerful. Oh my God. Let's continue, guys.
The point raised by the learned senior counsel for the appellant, Chief Chris Uche, particularly in respect of the application of Section 285(6) of the Constitution, appears to me interesting, attractive, but when taken along with relevant provisions of the Constitution, as well as the Electoral Act 2022, it will respect to Chief Uche Ezean spacious. As demonstrated in the lead judgment, the provisions of Section 285(6), even if the Court of Appeal is not specifically mentioned in that section, the provisions of Section 285(6) is applicable and apply to all proceedings in respect of all petitions, whether before tribunals or the Court of Appeal sitting as a court of first instance trying a petition named Presidential Election Petition, for which it was conferred or vested with the original exclusive jurisdiction to try and entertain under Section 239 1A of the Constitution. So I completely agree. This is an interesting point, like I said, because this is the first time it is coming up, and it is good that this court would make a firm pronouncement in order to avoid further or future arguments in respect of this particular issue. In addition, the issue of a candidate scoring 1/4 of votes in the FCT has also been settled by this court before now. And it is in line with that decision and position that the lead judgment had affirmed that the FCT is not elevated to a higher pedestal than any of the states of the Federation. It is, for the purposes of the presidential election, one of the states for which a candidate is required to obtain at least 1/4 of the votes in 2/3 of each of the states. So I totally agree with the lead judgment that this court lacks the requisite jurisdiction to entertain the application for leave to produce fresh or additional evidence, and that this appeal is also lacking in merit and deserves to be dismissed. I also dismiss the appeal, and that will be my judgment in this appeal. I abide by the consequential orders made in the lead judgment on cost to be borne by the parties for the prosecution of this appeal.
My little brother, Salawa, will deliver his judgment.
My learned brother, the Honorable Justice Koro
let us see all of you cause problem,
has accorded me the opportunity of a preview of the judgment that he has just delivered. I must say that I have read that judgment, and I'm very much content and appreciative of the far-reaching, erudite reasoning and conclusion that have so far been reached in the lead judgment. I concur with the highest sense of responsibility with the reasoning and conclusion reached therein. With particular regard to the interlocutory application, thereby urging upon this court to grant leave to the appellants to procure and transmit and adduce fresh or additional evidence at this crucial point in time of the appeal. I concur most assiduously with the conclusion that has been reached in the judgment of my learned brother that such an application is grossly unmeritorious, thus ought to be dismissed, and same is accordingly hereby dismissed by me. And as for the substantive appeal itself, which has been predicated upon a total of 7 issues, I agree entirely with the reasoning eruditely expressed by my learned brother that each of the 7 issues that have been canvassed and argued by the appellant are grossly unmeritorious, thus ought to be resolved against them. Without much ado, I hereby accordingly dismiss the appeal for being grossly unmeritorious. As usual, it is not the time for us to read elaborative judgments. Just like my learned brother said, 12 hours. We're not going to do that because learned counsel representing the respective parties in this appeal will have every opportunity to be served with the complete judgments of each and every justice of this panel in due course. Because constitutionally, we have a total of 7 days within which judgments must be served on the respective learned counsel that appeal. Thank you very much.
My Lord Jaro, read your judgment.
Thank you. Well, I have had the privilege of reading before now the lead judgment delivered by my learned brother, John Ikoro JSC. His Lordship has ably considered and resolved all the issues in contention in the appeal, as well as the application. I agree with the reason and conclusion reached therein to the effect that the appeal is bereft of merit and deserves a dismissal. The application, too, is not meritorious. Accordingly, I dismiss the application and the appeal. That is my position.
My Lord Abubakar.
Oh my God, this is so sweet. Obi, can I get the apple?
I thank my Lord the Presiding Justice, Honorable Justice John Ian Okoro, for granting me the privilege to read in draft the lucid and illuminating leading judgment just delivered in this appeal. I start with the application. The application seeking to adduce additional evidence or fresh evidence, I also find it lacking in merit. The application is frivolous and vexatious. It deserves to be dismissed, and it is hereby dismissed. Now, coming to the substantive appeal, I find no merit in the substantive appeal. It is also dismissed. On the whole, therefore, the appeal is dismissed and the judgment of the lower court is affirmed. Parties in this appeal shall bear their respective costs.
Yes, Iroko. Agim, JSC.
With the kind permission of the learned presiding justice, let me also express my view. I had a preview of the judgment delivered by my learned brother, Lord Justice John Inyao, JSCFR. I completely agree with the reasoning, conclusions, decisions, and orders therein. And I must remark that it is bristling with commendable erudition Let me, however, say maybe one or two things, since we will have opportunity, you will have opportunity to have our views, that the deposition is, for this additional reason, inadmissible. So if a document is inadmissible, you cannot ask that you should be allowed to bring it in as fresh evidence. A reading of the deposition exposes that it is not authenticated by the seal of the authority before whom it was issued. A deposition from another country to be used in Nigeria should prima facie bear features of authentication, such as the official seal of the court where it is sworn, if it is the court, or if it is before a notary public, his seal or signature, or if sworn before a person legally authorized to take the seal, or if sworn in the Nigerian Embassy, High Commission, or Consulate in that country, the signature of the officer authorized to do so, and the seal of the Embassy, High Commission, or Consulate. Such authentication is an assurance of the origin and authenticity of the foreign disposition. In our present case, the certified shorthand reporter, before whom the deposition was made, did not authenticate the deposition with her seal. She merely signed a certificate of reporter bearing her name and number, page 126 of Exhibit C. Being a deposition from another country, it cannot be used in Nigeria without authentication. The authentication of the oath administration is mandatory. I have wondered why the deposition said to be made pursuant to the 3rd October 2023 order of the United States District Court for the Northern District of Illinois in case number 23 CV 05099 for use in a foreign country was not made before the court in the said proceedings. And if made elsewhere in the law office of the first appellant's attorney, why was it not filed in the above-mentioned court? Because of the peculiar circumstances of this case, and adopted as a deposition made by the court, so that it can form part of the record of that court to enable the court issue it as part of its record, also authenticate it with the seal of the court and the signature of the relevant officer of the court. Page 1 of the deposition is headed in the United States District Court for the Northern District of Illinois in reapplication of Atiku Abubakar for an order directing discovery from Chicago State University pursuant to 28 U.S.C. 1782 number 28 CV 05099. This gives the impression it is a process of the district court, or that the deposition, though made outside the precincts of that court in a private law office, is part of the proceedings in case number 23 CV 05099. If it is indeed a process of the said district court, or forms part of the proceedings in case number 23 CV 05099 before it, then it ought to have been authenticated by the official seal of the court and the signature of the relevant officer certifying it as a true copy of the part of the record of the court in case number 23 CV 05099. Without such authentication, a deposition cannot be used in the Nigerian court as part of the proceedings or in the said U.S. District Court. And I've continued to wonder why the college, why the appellant did not use the advantage of the order of the district court that the college produced documents and a deposition concerning those certificates. Why they didn't use that advantage to secure a letter from the college under its letterhead, seal, and signature, disclaiming the certificate presented by the second respondent to INEC as not one issued by the college. That was not done. Instead, they resorted to this deposition, which has no features of authentication, thereby rendering it spurious and inadmissible. I agree with the able manner the lead judgment has dealt with it. I agree totally with all the reasons given in that decision as to why such an application should be refused. And it emphasizes one point. It was obvious to all, including those who brought it, that it was going nowhere. Then the question is, why was it brought? And I agree with my Lord when he described it as a vexatious process. I dismiss the application too. I go to the appeal. I agree completely with the lead judgment. I cannot say it better than that. It was a real brilliant expose on all the issues raised. Let me also join my Lord Garba to talk about a question of Abuja and 1/4 of the votes there, that the candidate must win. They view that the provision of the Constitution should be applied in such a way that the votes in Abuja must be won. 1/4 of the votes must be won by a candidate before he can secure victory in election. To me, violates a fundamental principle of constitutional interpretation, that it must be interpreted to protect the spirit of the Constitution. And if you look at our Constitution, it promotes egalitarianism, equality. So it must be applied in such a way as to protect the equality of the votes in all the entities, and not otherwise. I will expand on that in my judgment. So I do not agree with the interpretation placed upon it. Attractive as it may be, but we must bear in mind that there's no jurisdiction in the world where a constitution is read in isolated patches and given meaning that should have very narrow meaning that should appeal to certain sentiments. No, you apply it as a whole, reading it completely together, so that you rely on one part to get a meaning in another part, that the words can truly support the wordings used in that provision. That is how to read a constitution. Yet remembering that it is dealing with a dynamic system, a human society. For these reasons, I also dismiss the appeal. I also agree that the parties should bear their costs. Thank you very much.
Thank you, my lord. We are now left with the next appeal.
My own is that we need punishment. We need fine. These people must be fined. They should not only bear their cost, because I said the party should bear their cost. No, they should be punished. They should be fined. That is what I'm interested in. These guys are a bunch of criminals. They are a bunch of criminals.
SCCV 937-2023. Mr. Peter Gregory Obi, Labour Party, Appellants, Independent National Electoral Commission, INEC, Senator Bola Ahmed Tinubu, Senator Shetima Kashim, All Progressives Congress, APC respondents.
Appearances.
The Lordship, my name is P.I.N. Ikweto. My Lords, unfortunately, we have a type list of counsel, and by the time my colleagues brought it to the registry, they were told it was late. If the Lordship allow me, can I submit that list?
Please, sir, submit it.
Thank you, my Lord, sir.
They don't even know what.
And my Lord, with respect,
Judgment day, we don't go late to court.
I was here before. I was there by 8 o'clock, sir.
So that you won't be late when God will be giving judgment.
Oh, my Lord, on the day of my own judgment before the Lord, I will be there alone, so I will not be late there.
So,
and I'm sure you will accept me when I get there, sir.
God will accept you.
I'm sure He will.
I pray it should be so.
Amen, sir. My Lord, I want to say that my name is PIN Ikwetu, and your Lordship, with respect, we have, in line with your Lordship.
I think we should start calling you Saint Ikwetu.
My Lord, I cannot be while still on earth. Yes, sir.
Until you die.
While still on earth, I cannot be. I'm a sinner.
Let's find a place and discuss that.
I don't know where we can discuss that, sir. My Lord, we've taken the liberty to tick the names of my colleagues who are with me.
Azinge.
Number 3, Dr. Mrs. Valerie Janet Azinge, SN. Number 4, my Lord, Alex Ejesieme, SAN.
Azinge.
Yes, sir. Azinge is number 3, sir.
Yes.
Number 4, my Lord, is Alex Ejesieme, SAN.
Where is Azinge?
My Lord, Azinge is just beside me here. She's been here all morning with me.
Azinge used to be black. I don't know why she's white today.
No, she's always been fair complexion. Yes, sir. The husband is dark complexion.
Okay, it's the husband that is dark.
As a Lordship, please. Yes, sir. She's been fair complexion all along.
It's okay. You're welcome.
Yes, my Lord.
Leonard SN Ikwetu, did you say Valerie is number 3?
My Lord, on the list, she's number 3.
But she's number 2.
She's number 2, yes, sir. Yes, sir. I just want to make it easier for my Lord, son. The next, my Lord, is Mr. Alex Ejesieme, SAN.
Yes. Chike.
My Lord, as a Chike AOB Esquire.
Yes.
And my Lord, lastly, and in compliance with my Lord's directives, Ejiofor Onwaso Esquire. Your Lordship, the appearance with due respect is for the appellant in this appeal.
So let us.
Yes.
Please, my Lord. I am Sir Stephen Adehi. I am number 2 on the list.
Where is your list?
We submitted a list this morning, my Lord.
Stephen
Adehi, my Lord. Okay. Sir Stephen Adehi.
Leave that thing. Adehi.
Yes, my Lord.
Yes.
I appear with my learned friends of the inner bar.
Yes, yes.
Al Hassan A. Umar, SAN, is number 4 on the list.
Umar.
Yes, my Lord.
Yes.
Obi on is
and number 7, Wendy Kuku, Esquire, my Lord.
Yes. Yes.
Number 8, Jamiu Aguru, Esquire.
Where is Jamiu Aguru?
And finally, number 10, Z.U. Obansa, Esquire. Our appearance, my Lord, is for the first respondent. May my lords be pleased.
Is that for the... Yes?
I bet, maybe they do this one, maybe sound no fire person. Hi, Obi on will be the worst. Chai, Obi Kerenke. I'm not happy if there's no punishment for this thing. There must be punishment for all these things. I'm not really with that because we'll continue again. There must be punishment.
Tell them that this thing.
That is my own. There must be punishment for all these things. It's not just for them to bear the cost. There must be punishment.
This thing can amount to contempt of court, so they should be careful.
My Lord, the last person on our list, my Lord, is actually number 9, Amira Hamisu, not Obansa. Number 9.
Who?
Amira Hamisu, Esquire. Yes, my Lord. Not number 10, my Lord. Thank you very much, my lords.
1, 2, 3,
you listen to the comment of one of the judges concerning Atiku's certificate all the way to the US? It's an insult to the Nigerian government. It's an insult to the Nigerian government and the Nigerian court system. Atiku.
If it pleases mind of
I don't know why.
My name is Akintola Makinde, and I appear with my colleague, Okpe Moritala. Your Lordships, we submitted a typewritten list in the morning. Very respectfully, our appearance is for the second and third respondents. We are very grateful, sir. Okpe Moritala, my lord, is number 2 on the list here.
Yes.
We are very grateful, sir.
Yes. Yes.
Respondent.
Yes.
Appearing with me, I'm learned friends. My lord, I'm sorry, the next name is not on the printed list which you submitted.
Let me, okay, here.
Professor Abdul Karim Kana. And Abdul Wahab Abayomi. We all respectfully appear for the 4th respondent. How much obliged, my lord?
For the 4th respondent.
Respectfully, my lord.
I believe that this judgment today is a good lesson for all the Obingo bingos. You understand me? For all the Obingo bingos. It's a shame. It's a shame. They say they won't burn down Nigeria. Will they wait for them? They are fraud. Never say anything. You know, I think say na Buhari do this. This is not Buhari government. This is the city boy government. You understand me? Renewed hope. You understand me? This is renewed hope agenda. It don't they happen. They play. A town hall different from Baba Blue. This is the one. I don't see him now. This is complete town hall different from Baba Blue. I mute the sound because they are not saying anything. He was making a lot of noise. They are not actually saying anything. You understand me? A town hall different from Baba Blue. So guys, what do you have to say? The judgment already. Of course, this was a very, very. In fact, I wasn't thinking that the judge is going to make that. In fact, it was a very resounding conclusion by the Supreme Court. It was a resounding conclusion that the application, the petitions, the appeal is of no basis, no standing. It would not yield to anything positive. I hereby dismissed it, and I can affirm to you that yes, President Tinubu is indeed, or was indeed, or yes, the winner of the 2023, of course, election. Simple. It's as simple as that. Man, these guys, that's it. You understand? So how do you feel? How do you feel? Because I know that this Obi had lack substance. You understand me? We need punishment for criminals. That is my own. Let us
dealt with in Atiku's appeal. It is the decision of this court that this issue shall abide the outcome of the issues as resolved in Atiku's appeal, mutatis mutandis. As for issue number 4, which has to do with double nomination, which was not in Atiku's appeal, it is the view of this court that this issue, having been dealt with by this court in SCs to CB to 501 to 23, which judgment was delivered on the 26th of May 2023, this court cannot allow the matter to be relitigated in this very court. There must be an end to litigation. For us to sit down now and talk about when this man resigned, or did not resign when they did a fresh conference or fresh primaries to replace him, which we have done before. We're not going to do it again. This matter ought not to have come here. When the matter was pending at the trial court, this court delivered that judgment. If you read the judgment of the lower court, they mentioned it, that Supreme Court has settled this matter. And that should have been the end. You now bring this issue of double nomination for us to sit on it and write another judgment. This is not how it should be. This appeal lacks merit and is hereby dismissed.
Did you hear that?
My lord, to my
These
right.
guys are criminals. They don't want to cause problem.
I agree with my learned brother, Justice John Ian Okoro, that this appeal, number SCCV 937 2023, Mr. Peter Gregory Obi and the Independent National Electoral Commission lacks merit, and it is also dismissed by me.
My lord, Garba Jesse.
I also totally agree with the lead judgment that this appeal substantially canvass the same issues with the appeal number 935 2023, which this court has very comprehensively dealt with, and there is no need for us to repeat ourselves because the issues are the same. The only issue that's different, like pointed out by my learned brother, the PJ, is that about double nomination, which you have settled, and we do not intend to reopen it again in this appeal. On the whole, I also join the lead judgment to dismiss this appeal for lacking in merit.
My lord, Salawa.
Having had the privilege before now of reading the draft, the judgment prepared and delivered by my learned brother, Okoro JC, I cannot but concur with the far-reaching reasoning and the conclusion that has been postulated in the judgment to the effect that the instant appeal lacks merit, thus ought to be dismissed by this court. Having associated myself with that reasoning and the conclusion, I have no hesitation whatsoever in dismissing the appeal. Appeal dismissed.
My lord, Jauro.
I had the advantage of reading in draft copy of the lead judgment just delivered by my learned brother, John Ian Okoro JSC. I entirely agree with the reasoning and conclusion contained therein that the appeal is devoid of merit and it ought to be dismissed. Consequently, I join my brother in dismissing the appeal.
My lord Abubakar Jesse.
I also had the advantage of reading in draft the judgment of my learned brother Ian Okoro JSC, and I am of the view that the appellants have nothing useful to urge this court. The appeal lacks merit, and it is hereby dismissed by me.
My lord Agim Jesse.
I had a preview of the judgment delivered by my learned brother, Lord Justice John Ian Okoro. I completely agree that this appeal lacks merit and it should be dismissed. I hereby dismiss it.
Thank you all for listening. The two appeals, I think we have concluded our job today. What remains is for us to go and rest. Thank you very much. We shall rise.
Otilo. Otilo! 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 Jagaban! 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 On your mandate we shall stand. On your mandate we shall stand. On your mandate we play. On your mandate, on your mandate we shall stand. We shall stand. On your mandate we shall stand. On your mandate we shall stand. On your mandate, on your mandate. I don't even know where to start from. Is Obi coming? There was no room for anything. In fact, I'm not happy that there is no fine. I'm not happy because I'm not aware anyway. Because I'm still thinking. You know. Yes, let us listen to Femi. Femi. Yes.
Like the judge said, all litigation must come to an end.
That's it.
They addressed all the issues, about 7 of them, and those issues were, and the judgments on each of the issues is clearly, or were clearly assailable as far as I'm concerned. So for me now, is the time for us all, Nigerian, particularly the president, to roll up his sleeves and continue with the governance. This has been a distraction. The litigants exercise their rights to go to court, but that has come to an end now. We now have to all come together as one country, one people, and move ahead and take this country where it rightfully should be. We're happy. We're excited.
So coming together, does
yes.
that mean that you'll be extending a hand to the PDP and the Labour Party? Although the APM's appeal was dismissed, but would the president be extending a hand of friendship or sportsmanship to the other
parties?
Listen, we shouldn't take these things personal, right? If you listen carefully to the judgment was very sound. By any objective, right-thinking person, supported with facts, with cases, with statute. The president, if you know him very well, is a Democrat. It's not now that he's extending his hands of fellowship. He's always done that. He will continue to do that, and will continue to do so on his behalf. Governance is about everybody. It's not about a party. It's not about an individual. And if we do not come together now, then we'll have ourselves to blame. Opposition is not, you don't oppose for the sake of opposition. Elections are over, litigation is over. All litigation must come to an end. Now is the time for governance. Distractions over. So yes, Mr. President, the APC, and all rightful thinking members of the society must come together, no matter what party you belong to address the issue.
Any distraction must have consequences.
Thank you very much. Yeah.
Any propaganda must have consequences. We need focus in this country. Every criminal must be punished. That is my own. You understand me?
Okay. Well, I want to first give all the glory to Almighty God for this judgment. That the Lord has made. We're glad that this puts an end to all litigation and a closure to all the speculations and all that. Mr. President, in his magnanimity, I'm sure will now reach out to all to join hands with him in his renewed hope agenda. APC was his platform, but the Nigerian state is where he's president of. So this is not just a victory for our party APC, it's a victory for the country. And we want to salute the judiciary, starting from the Supreme Court, the appeal court. Their judgment was very detailed. It was very meticulous. It laid the foundation for the Supreme Court judgment. I want to salute the judges of the Supreme Court as well. It was straight to the point. And I believe that this judgment would be seen worldwide as that which is in line with global best practices in law. I want to salute them again because, you know, they are the bastion of hope for everybody, including the common man. And this is a victory for democracy. Opposition can now go and rest. If they indeed mean well for this country, I expect that after today, they will call President Bola Ahmed Tinubu, they will congratulate him, they will now sit down and fashion out how to join hands with him in ensuring that indeed we achieve and continue to achieve our pride of place in the Committee of States across the length and breadth of the world. Once again, I congratulate President Bola Ahmed Tinubu for this victory, and I congratulate APC, I congratulate Nigeria. Thank you very much for having me. Thank you.
Yes, just one question.
Okay, what is it?
We get my man.
The FCT has no special status. As the minister of the FCT, what do you have to tell me?
Maybe you don't understand when he said FCT has no special status. What he said that in terms of calculating or having the status quo, you must not win FCT before you are declared president of the Federal Republic of Nigeria. That FCT is like another state. So that you don't need to say, oh, if you don't win FCT, therefore you cannot be declared. That's what he said.
So you must have start with the APC crew. Can we say that you have moved to the APC?
I didn't come with APC crew. And in the court here, in the court here, I don't know where they said APC and the PDP. I came here as somebody who's interested, as somebody who wanted the country to move forward. So I congratulate Mr. President, and I think that this has come to the end. No more speculation. So Mr. President can focus and do what he's supposed to do for Nigerians. Thank you.
Thank you.
Election
litigation and the delay it election litigation and the delay seems to constitute distraction. Will you be moving for some form of amendments?
Well, you see,
what advice to your opponents?
well, you see, this is a developing democracy in a developing nation, so you expect such distractions to occur. But I believe we fine-tune our laws, especially electoral laws, and and we believe we shall come to the mature stage that we are expecting. Pertaining to acceptance of this verdict, I urge our colleagues, politicians, to accept it in good faith. And also I have to use this opportunity to congratulate politicians, to congratulate the leaders of the opposition political parties, because it is better for them to resort to judiciary, which they have done so, rather than taking, arms against against each other. Yeah. So we have to congratulate our politicians for resulting to judiciary, and the judiciary has done well. It means that democracy is getting matured in Nigeria, and we are happy with that.
And I like this version of his conversation. I like the version that Kanduje deal with. He said we are developing democratic nation, and every other thing will be dealt with. This is, oh boy, President Tinubu team is made up of intelligent professionals, technocrats, and experts. Did you see the conversation? they crushed Obi. They crushed Obi, crushed. My God, I'm so much happy. Celebration time. I need to dance now. I need to do my own dance. Hey. Tinubu dance. Oh my God. I cannot wait. This is powerful. You understand me? This is powerful, guys. Celebration time. Did you listen to all the comments? There was anything that they... Hey! Oh my God, this is powerful. This is powerful. Hey! It don't be. It don't be. This is powerful. What do they want them to say again? Where are the bingos? Come out. Come out and make noise. We'll deal with you. Hey. Oh my God. So guys, I think everything has finished. On your mandate, on your mandate, on your mandate, on your mandate, we shall stand. On your mandate, we shall stand. On your mandate, we shall stand. On your mandate, on your mandate, on your mandate, we shall stand.
And that has been the proceedings from the Supreme Court here in Abuja. Yes. Shola Shoyele reporting for Channels Television News.
Okay, guys. I don't know what else you are going to report. There's nothing else to report. The report is finished. Let me hear this. Hold on, guys. Let me connect to TVC. I like the conversation now.
In presidential election, so many things there that we also need to talk about. The reason why you were able to watch this earlier today was the fact that it was also allowed the Chief Justice of Nigeria, Olukayode Ariwola, approved the live transmission of judgment. So everything that went on, it can also, according to the court, it can also be assumed that jurisdiction can be conferred on the court by parties. So the Supreme Court said it cannot do what the Court of Appeal did in many of these issues which they brought up. And also the Supreme Court said it cannot also invoke Section 22 of its Act after the 180 days for the trial courts deliver judgment has lapsed. Then a petition cannot amend its petition after the 21 days allocated for filing petition, which has lapsed in line with Section 134. Subsection 7 of the Electoral Act. One of the petitions, according to some of the petitions brought by the PDP to the Supreme Court, which the Supreme Court described as shocking, is that the lower court no longer has the jurisdictions to entertain any fresh applications. It makes it clear that the Supreme Court has no jurisdiction to entertain same. And he also added that there is nothing in Section 285, subsection 6 of the Constitution that suggests that the Court of Appeal can hear election petitions without time. So the argument by the PDP that the Court of Appeal is not caught by the 180 days after provision, since the appeal was not described as a tribunal in the Constitution, is false. So the Supreme Court then said that it can't accommodate a case of torture. So, it gave instances from the citing from similar cases and instances from previous rulings. One of it.
You read something, you get to the end of the page, and then you forgot what you just read, and you go back and you reread.
It's adverto. I don't know. Let's the advert finish. It's adverto.
Party president from EC9 to 21st of March 2023. When they filed their petition. They also talked about the issue of electronic transmission of results, which is said that the only time when electronic transmission of results becomes relevant is when there is no written hard copy of the results. So the petition seeking to nullify an election on grounds of non-compliance must establish that. So in the judgment of the Court of Appeal, the appellant abandoned their duty to prove compliance. And on, interesting conversation that talked about the 25% of the votes which it also clarifies the issue status of the FCT, saying that it doesn't enjoy special status. You know, in summary, that there is this striking of the PDP's weakness as well. That for the Labour Party, it was also the Supreme Court also adopted the position held in the appeal filed by the PDP in the appeal filed by the Labour Party, which is dismissed in the appeal filed by the Labour Party. So they said the only difference in the two appeals is the issue of double nomination, which Labour Party alleges the Supreme Court has already decided on that issue, according to them. So all of these and on, you know, so many talking points to bring to, you know, your hearing, some of which you saw live, what we are giving you the live transmission of what transpired in the courts today, with, you know, using simple expressions, simple language without legalese, you know, to burden Nigerians. Let me bring this to my colleague, Mr. Ayodele, who are monitoring the Supreme Court's judgment all day, you know, to have one or two conversations as regards this. Ayodele Ozubako, it's good to see you this morning.
I like the analysis
been,
of
you know, long time coming. It's been a long time coming. We've been looking forward to today, how it's going to pan out and all of that. You know, with all of this hulabaloo, what do you think this, you know, judgment, you know, bring to the fore now?
I wasn't expecting anything different. I've been covering elections since 1999, and those elections have been getting to, have been subject to litigations, and they've gone to Supreme Courts right from the time of Ephraim Akpata, Abel Gubadia, Morris Iwo. Those elections, they've gone as far as going to the Supreme Courts, and the only thing here is that when this is one of the most keenly contested elections, that you have live viewership for the Court of Appeal and the Supreme Court verdicts that everybody has been monitoring. So it's done and dusted. What is there is what Justice Okora just said. There should be an end to litigation. Now, governance should start. What they've just done today is just to affirm it, that the February 25th presidential election was actually won by Bola Ahmed Tinubu, and of the All Progressive Congress. Every other loopholes, you know, before now, the Atiku Abubakar tried to go to the Chicago State University, you know, and the Supreme Court.
Guys, let us, I'm sorry, we're going to come back.
You know,
let us join,
forum shopping.
Let us join Arise, so that we hear what they are saying. It's like they are very, very angry. Arise TV is very, very angry, guys. I can see, what's his name? Kenneth Okonkwo, very angry and so feeling so bad. Let us hear from him. Oh my God, I missed it. Yeah, because I saw him shouting and angry very, very well. Oh my God, I missed it. Yeah. I missed it. Okay, but let us listen to them a little bit. Hopefully, they will come back again with the analysis of they are so angry, guys. The Arise TV people, they are so mad as I'm talking to you. So let us hear from them what they have to say here.
The Electoral Act is convenient for it, which is what really happened, and which is what the appeal court for the presidential election, which is what they upheld. So it is not strange to me. And then on the issue of Abuja, as 25th state, you see, the Court of Appeal judge went into the memorandum of association preceding the election, and he said, look, the spirit of the Constitution is there, that you cannot say because somebody has not won in one federal capital territory, even if you have won the majority of the seats in the 36 states, you say you cannot win the election. That is not, it's not logical. So I respect the reasoning behind the decisions of the courts, not wasting time in putting an end to litigation and allowing us to continue with our political life.
It's true.
It's a good development.
You know, everybody
can appeal again. So we have governance for 4 years. Well, and I'm happy with that.
You certainly hear it, but Mr. Finney, I'm wondering, based on what was, stated, like IREV and the FCT 25%. Do you think we're going to need to see the need for more clarity as we move forward with our democratic process for subsequent elections?
Well, the issue of the 25% of votes, I think is very clear. And because the appeal court sitting as the presidential election petition tribunal dilated seriously on that. And I think the Supreme Court wholly adopting that position had put to rest the issue of Abuja and 25%. There's no argument about that anymore.
Yeah.
But the issue of what you said, INEC can interpret the law. I don't think that's what you were saying. On the issue of mode of transmission of result, because the law did not state expressly that INEC must transmit electronically. So INEC is
discretion.
Yes, it's in a position to use its discretion to transmit in whatever manner it chooses. In INEC, but after all this, what we have gone through, whether Nigerians have more confidence in INEC now. What I think that was Kenneth Okonkwo, lawyer, actor, member of the Labour Party, was saying that the Supreme Court also said something that the fact that INEC did not keep to its own promise of transmitting result on IREV real time
will not affect the
will
results.
also affect the confidence of Nigerians. Yes. And I think that was also a spillover from the judgment of the Presidential Election Petition Tribunal. We stated that though INEC made promise, gave assurance that it will transmit the result real time, it went further to say that INEC assurances are mere promises. But some other people will say, yes, henceforth, INEC's assurances that are not based on the law, that gives it where it has discretionary powers, should not be taken too seriously. So my own recommendation is that when INEC gives assurances that are not based on the electoral act, then they should prepare for all scenarios. Because I think the hue and cry you are hearing from the other part, oh, INEC promised. Yeah. They gave assurances. In London, in Nigeria, they were giving assurances. But at the end of the day, they did not transmit those results from the polling units into IREV real time.
So the question now is Obi going to congratulate
the fact that they did not do that does not mean the results were not available, because they were available in hard copy, which all the parties had a copy of from every polling unit, because you had your agents there. And they were given.
So INEC can always use its discretion.
Yeah, so INEC can use its discretion. That's right. And perhaps some of us will say, baby, INEC has the right to change its mind.
You know what, on that note, Mr. Shobala, I want to bring you in because prior to this, to the Supreme Court hearing, there was a lot of discussion about the fact that is this outcome going to be an outcome of technicalities? Based on what Mr. Feni just said, it almost feels...
I've not read the judgment.
No, I'm just looking for your take, because some people may come in and say, as Mr. Feni is saying, well, INEC promised, and the court is saying, well, this isn't written in the Electoral Act, it's an INEC promise. So that seems like a technicality to me.
No, but I've not even said it's technicality. It is not technicality.
It's an interpretation of the law.
There's no way it's that in the law that INEC must transmit in this manner. Mm-hmm. So INEC can transmit.
The sequence
so
of
INEC, that is not technicality as far as I'm concerned. The Supreme Court, flowing from the Presidential Appeal Election Petition Tribunal, I think they just stated the law.
Yes.
There, well, maybe lawyers will have.
Law. Maybe stating the law is not technical.
Maybe lawyers will have maybe some lawyers will have a different, but to me, I don't think there's technicality there.
Of maybe the time for you to bring in this as lapsed and things like that, while leaving the substantial issue on justice. That is what people are skeptical about. But on this occasion, they interpreted the law. You get me? Listen to INEC's defense. Listen to what the political antagonists were saying, and took a decision on point of law and procedure.
Indeed. Oh,
yes.
Mr. Finn, you mentioned earlier that it was stated that INEC's promises are basically assurances, and as long as it's not...
The
assurances are promises. Which one is it? Assurance, promise, I guess it's interchangeable at this point.
Yeah.
Yes, but my question now is, based on that, I'm being told to pause. Okay. We have a video of the president reacting to the Supreme Court ruling. Let's take that and we'll continue our discussion here in studio.
The president!
Hey! Thank you, sir. Congratulations.
Oh my God.
Stop.
Congratulations.
Congratulations to the president. Having been confirmed by the Supreme Court as the 5-star general. Yes. As the commander-in-chief of the armed forces of the Federal Republic of Nigeria. Thank you. Congratulations, Your
When is Obi congratulating the president? When is Atiku congratulating the president? Because it don't happen.
I think the hashtag for today will be your job is secure.
Your job is secure. Based on what must be a sign of relief for many, but I expected.
Yeah. So, I don't think we expected any different reaction. But Mr. Shibol, you want to talk about this before we go back to what we were discussing?
Which one?
This reaction of the president to the judgment.
You asked me what you want to. You asked me a question.
Okay. What do you make of what you see? Are you surprised? Are you thrilled?
Why should I be surprised? It's even subdued that he even seated. You get it?
Good. Okay, Mr. Ifeni, any reactions to hashtag your job is secured?
Well, the president, I'm not sure that he was too anxious this time around compared to the verdict of the presidential election petition tribunal, because basically at that level, the judgment was extensively espoused, and I'm sure he wouldn't have been more ruffled so much today. But you can see he was sitting easy, although some of the aides there want to go overdrive. haven't been confirmed as a 5-star general. Well, the president.
Yes, we're just speaking English. There is over excitement. Oh boy. Una better cut on this thing because they don't know waiting to talk again. This is Arise. They are mad. They have ended it because they don't know what to say. Look at Arise TV.
Well, they are happy, and I think the president should yes, the president should, of course.
Arise TV.
Privately will celebrate. And thank God.
Yeah. So of course,
after all the legal gymnastics and mortars and battles, everything has come to an end now. So we can have some respite and peace in the land.
We can say democracy in progress, and of course, it's part of the democratic process that people.
Somebody say, sorry guys. Somebody say, Obi and Atiku will not be able to congratulate the president because of shame. Shame will not let Obi and Atiku to congratulate our president. No, the president already knows. He said you can lose or win. In politics, you have to lose and you have to win. You don't win every time. Sometimes you win, sometimes you lose. So they should prove to the whole world that they have the interests of the country at heart. There is nothing else we're expecting than the president to win, to always win in everything. My brothers, I've told you, I support winners. I'm part of the winning team. Are you getting me? I cannot be what is on? He said, please, where is that big mouth, small church and bail lawyer, Okonkwo, Nollywood clown? Uche Victor, sorry you. Is a proof that Obi can never become the president of Nigeria. Let Obi go and do his miracle. Go and consult all the bishops. If Obi know what is good, he should put his money into something else. After all, he's not even putting. He never used his money for anything. They are donating money, so that is why he can afford to do anything, because he doesn't want to give account. But we are happy that this has come to an end. If they like, they should bring their propaganda. If they should like, you understand me? If they should like, they come and do what they should do, whatever thing they say. It is not time for Simon Ekpa. Simon Ekpa said he want to burn down the country in November. That is what he said. He said, I will burn down the country. You understand me? So where is Okonkwo? Somebody say, where is lawyer Okonkwo? How can it does not even fit in. Lawyer Okonkwo do not even fit in. Did you see? It doesn't even suit him at all. He's a Nollywood actor. He's an actor. Let us talk about actor. You know what is the statement of Obi and Atiku? They are quiet. Maybe Obi and Atiku is in consultation now. Remember, Obi made an appeal. Well, wait, let me play a video that is very, very important right now. I think it's very, very important. An interview with oh my God, wait, let me see it. Oh my God, hopefully I can see it. A quick interview with Dr. Ruben Abati, even declaring it that they all came. They said they want to come together to fight. So now it is possible that Obi is now in a meeting with Atiku. It's possible. That is why we have not heard any comment from Obi. You understand me? There is no comment from Obi. Guys, let us just continue at the moment. Okay. Hello.
Because in a democracy, the majority will have its way. The minority will have its say. That has played out splendidly. You get me? From the electoral, from the ballot box, you get me? To the announcement of the results, to appeals, to petition against the result, against INEC. INEC too has defended itself, has gone to Court of Appeal, has gone to Supreme Court. We have gone through the gamut of the entire democratic process. I'm proud to be a Nigerian who have witnessed that. So I'm happy. So let's go on with politics. Not yeah.
Well, Mr. Thank you for raising your point, of course. Yeah. Mr. Feni, I want to go back to what you mentioned earlier about assurance and promises, and that as long as it doesn't, please correct me if I'm misquoting you. You said the promises are simply assurances, or assurances are simply promises. Which one is it? First of all, let's establish that.
INEC's assurances are mere promises.
Are mere promises.
Thank
you.
From the appeal courts.
So, when you hear that, and you think about the everyday Nigerian that held on to INEC's word, the assurance or the promises that they gave, and now they're hearing that as long as it doesn't line up with the Electoral Act, they're not bound to that. What do you think that does for subsequent promises or assurances that the electoral body might make to the electorate?
Well, let me first talk about the point Femi Gbajabiamila made, the chief of staff to the president, on governance starts now. Yes, because as long as you have these cases in courts, it's a form of distraction. And perhaps that's why there's been this conversation about how we can ensure that all election cases are dealt with, finalized before swearing in. And it is an option Nigeria must view very seriously. Because if Kenya can do it, why can't we do it? So when a president has been sworn in, the court case, was sworn in May 29, and this is October 26. How many months? So it's a distraction. So now that has been put to rest. The president will concentrate, and his team, they will concentrate fully on the issue of governance. But the issue you are talking about as for INEC, I don't think we should just throw INEC under the bus. Because what INEC did, perhaps we just attribute it to the chairman of INEC, making a promise which it did not keep at the end of the day. They said they were glitches.
What they call?
They talk of glitches. That was why they couldn't keep that promise. So perhaps also going forward, INEC must promise what it can deliver. And perhaps we need to take another look at the electoral law 2022 also, so that some loose ends, because if the law says this is the mode INEC has to transmit the result, then it will work towards that, and it has to be that, or that election will not be valid. But in a situation where it has discretion, of course it can use its discretion. But the problem is when you promise one thing and you don't deliver on that, and you do something else, that is where the problem is. And INEC cannot be faulted on grounds of law because it has discretion, according to the law, to transmit the result either electronically or manually. But if we want things to be clear-cut, then perhaps we have to amend the to determine that, look, this is the mode through which INEC must transmit its result. On election day, from the polling unit, the result must be immediately available in IREV so that every Nigerian can view the result. You can sit in your home and view the result from your polling unit, whether it tallied with what was announced when you were there. So I think that's where we should be working towards. This election has been concluded, so whatever we think are the infractions or the shortcomings, we must sit down and look at the law to plug all the loopholes, because politicians are also crafty. Especially not just Nigerian politicians. Of course, Trump is a crafty politician.
Mr. Shabal, very quickly, I just want to, I know you have a comment, just to buttress what Mr. Efenia said. Counsel to PDP, Mike Ozekome, has commented, and he said Nigeria is a work in progress, which chimes into this conversation. So I'd love to know what is the work?
Precisely what I was going to say. Democracy is work in progress. I see our election has walked the gamut of the entire process. It has been interpreted at the final end. So what you can do is a postmortem on what transpired. You get me? And I want to add something. You see, it's not as if the rules are faulty. You get me? You make rules. The Constitution is there. It is when the workings of the Constitution are in place that you know its shortcomings or the interpretation of various modes you assume as given. Do you get me now? It doesn't mean that we need to tinker with the law every time. But this is, it's a dynamic situation. It's a dynamic situation. We learn every day. And where there is ambiguity in the rules for the elections, we sort out the ambiguities and clear them so that there is clarification. That's all you need to do. You get me? If the government likes, it can retain INEC. If it does not, it can reconstitute it. It is an ongoing work in progress. Democracy, we learn by the day. Before in England, they had no written constitution. They didn't have a Supreme Court. They just had it some years back. Because 80% of the constitution was unwritten. So we learn. But our own is so much well written that you see, you need to interpret almost everything. Just like the judge gave a lecture in the Court of Appeal on the inclusion of Abuja as a state or as a federal capital territory. So we learn by the day. And there's something called constitutionalism, which is working according to the dictates of your constitution. That is what you have achieved. You can't please all parties, because we contested at the election. Some people lost. You get me? So some will jubilate, some will sulk. That is the nature of politics until the next election. That is what democracy is all about.
And speaking of the next election, of course, we're just counting down to off-cycle elections coming up very soon by Elsa Imo State. Mr. Efeni, what impact do you think this ruling will have on what we're going to see in those, very significant elections that are coming up?
Well, the off-season elections are usually opportunity for INEC to not only correct whatever shortcomings there are in past elections, but also to even test run new ideas. So, INEC has, I don't want to use promise, has said, that
you have to say something.
no,
the person
yes,
conducting the
INEC has said
the promise
the
service leave
will work. The election, the results from the polling units in this off-season elections in Kogi, Imo, and what's the third state now? Bayelsa. Yes, will be transmitted, will be there on IREV. So, but I'm sure the politicians, they know better now what not to trust, prepare for all scenarios, so that you don't say, oh, INEC said so and did not do so.
You see,
just prepare for us. Because before IREV, we were doing elections, and politicians ensure that they get copies of every result in every polling unit. It's available to all political parties participating in elections.
We'll come back, but we're going to cross live to Abuja, where our correspondent Godfrey Eshomoge is by to fill us in on what's going on. Godfrey, it's been a busy day, of course. Please fill us in on the latest.
We are all right. Thank you, sir. Thank you, sir.
Finally,
so guys, that was arrived. They don't know what to say anymore because we have defeated them, guys. They don't know what to say anymore. We have defeated them, and this is the story. This is how it is. We'll always defeat them. We are aware that they are planning something November 5th, which we are going to come back and talk about it. We want the federal government to deal with criminals. All of them are criminals trying to run down this country. They are planning evil. Obi and Atiku, all of them are planning evil, using the Abia fraud criminality to plan evil. November 5th is when they say they want to plan evil against the country. It was over on May 29. I salute you. Ijele speaks. It was over on May 29. That was the day it finished, because I told them, you don't win election, you win election at the polls. Finish. That is what you would have done. Right now, you want to cause problem everywhere in the country. Guys, I want to open the line. If you want to say something, this is an opportunity for you to say something. Let me open up the line. Let me hear from you. If you are available and you can talk, please, you can call in right now. Let me put my number on the screen. What do you feel? How do you feel? Was it not what you were expecting? What is going on? What do you want the government to focus on now? What about the threat of the criminals? They say they want to scatter the country. They are planning something November 5th. That is why you are not hearing Obi saying anything right now. Because their evil plan will not work this time around. I salute you, sir. Hello, sir.
Congratulations.
Congratulations, sir. Congratulations, sir.
Yeah, you know what? The case is over now. Congratulations to Mr. President.
Yes.
And now, the Aso pillar, Mr. President, who is the overall chairman there, let me put it like that.
Yes.
Is going to use that his power. You know, it has been silenced since all these days with all these propagandas from this miscreant.
Yes.
And he's going to use that full power now.
Okay.
Because he's not newly elected president.
Yes.
Officially. Understand? Because the Supreme Court have already declared as the authentic president now.
Yes, yes.
Between now and then, you will see a lot of changes.
Yes.
All this propaganda will stop immediately.
Yes.
We have a meeting. We have a meeting with all the ministers now, the paramilitary head and the military head.
Yes.
You will see a lot of changes.
Yeah.
And it will be
because they say that they want to bomb, they want to scatter the country November 5th. Yes.
Even though if Obi is not careful, you know what? Quote me right. You see Obi will leave the country for a while now.
He has already run now. He ran last night. Obi disappeared from the country last night. He wants to hide. He's hiding. He's hiding.
That idiot in Finland, you will see the meaning of power now. You know, power is just being declared authentic now. So that is all those. You see all this killing, whosoever that is sponsoring them here and there, all of them will run away from the country.
Did you even hear what the judge said? Something, it caught my attention. The judges, one of the judges said that that they should stop all this rubbish that they are doing. That Atiku and Obi should tell their supporters to stop sending messages, threatening messages to them. That all of them have been doing social media trial. That it will never, that the application will never yield anything positive. I hereby dismiss. Oh my God! If that is sweet me.
That single word there, they are telling Tinubu, like
we have to do something about the social media. Yes, we have to.
Yeah. We are telling him under the curtain, like, dude, do your job as a president.
Mm-hmm.
They don't have to open up their mouth to tell him, like, all this miscreant that's spread all over the world.
Yes.
Propaganda, to throw propaganda up and down.
Yes.
They will be picking them. Even though, no matter how big you are, how they go, you know, after today, you will see a lot of changes.
They will not even talk anymore. Let them do anyhow.
Let them do anyhow. We will not use that power of office to intimidate them. It's Tinubu now, they know. I think we know how far now.
I like what you say, it's Tinubu now. What is your take? Sorry, sir. I wanted to ask you, what is your take on these dollars? Every time the Biafra criminals, they will be shouting Biafra, dollars. Why are they so much focused in dollars?
How many of them seen dollars before? Are we spending dollars in Nigeria?
That is the point.
Understand? The inflation is everywhere. Understand? Some people are passing through hyperinflation, and some people are passing through primary inflation. How much is the Japan yen to dollar? 1,000 plus. It's not even about that. We're not spending dollars. The problem now is that the insecurity, how is the president is going to tackle that? How people will go back to farming? Understand?
Yes.
Or the civilization that we said we are copying, you know, from Western world, it's not helping us. Understand? How are we going to focus on the afforestation back? And how are we going to, you know, give people, you know, all these farmers loan to start farming? Without farming, we are nothing. If we have food, understand? If we have food, we won't talk about poverty anymore.
Yes.
Food, number one. Let's put food on our table.
Yes.
Let the Mr. President work with community leaders. And this is one thing. The insecurity, the security of a nation is not about it from the federal government alone. It has to start from our household, our community leader.
Mm-hmm.
What are they doing?
Yes.
That this is the item we have to focus and drag our governors.
Yes.
What are they doing with their allocation?
Yes.
Why is it got to this point that they are unable to pay 1 year's salary after receiving allocation? It is our responsibility not to come on social media and defending all this celebrity. That is not our problem. They are making their money. Our problem now is to focus on the state. What are you guys doing with rural development? What's wrong with local government allocation? The autonomy that belongs to local government, they have to return it back to them so they can work. So that is when we can say, okay, community health care, the rural road and rural electrification. We need that back. Understand?
Yes.
How our community leaders are going to tackle insecurity?
Yes.
How are we going to form a rural network security back to our community?
Yes.
Who are the new faces in those communities?
Yes.
And they have to raise alarm. Like, okay, we don't know this guy. He has been going up and down with bike. And get him arrested. Where are you from? All those things, that we need them back. That is how we can develop as a nation. Even if we focus on just cassava and maize, and for exportation, we can get fuel from cassava. We can get ethanol from cassava. We can get fuel from cassava. A lot of things. So all these nodules. If we focus on cassava for 2 years, my brother, you will know how the billions of dollars we are going to make from that from exportation. Even if you focus on African nations alone, exporting all these things to all those countries, from Ghana to Syria alone. We are going to make billions of dollars.
That is what I'm saying. Our president actually made a signature statement during his campaign. He was talking about cassava, agbado. Those things are important, and they were laughing. They were laughing because they don't understand.
Because they are dumb. They believe that for a country to develop, it's all about factory. Bring foreign investor alone. No, we have to do something as a nation too. We don't have to focus on the all these solid mineral resources, petroleum. It's never done. Understand? And you know what? When we focus on agriculture, everybody can, we can give the small employment we can give each other is to focus on agriculture.
Yes.
Everybody cannot work at what is that? NNPC. Everybody cannot work at the Federal Ministry of Water or this and that. What about the less privileged people that don't have a quality and quantitative education? Those people are the majority in Nigeria.
Yes.
So we have to focus on something that everybody will benefit. Let's bring maybe China company that will set up a gigantic biofuel company. So they can buy all those cassava from us. Let's Dangote focus on. We have a lot of billionaires in Nigeria.
Yes.
They can come together like 10 and establish a big factory for noodles.
That is what I'm saying.
Understand?
So I believe that our president knows the answer to these things. It's very easy. We don't care about dollars or whatever. Forget about dollars. Let our government discourage anything importation of food. Let the government invest money. There are many people that are ready to farm, to do all these things. Provide security. Let us produce our own food. Simple.
But my brother, that insecurity is number one.
Yes, it's a number one priority.
Nobody can go to farm anymore.
Yeah, but okay, do you want me to tell you the truth? The government know the people that are responsible now. Let President Tinubu stop them.
They need to get them arrested.
Yes,
you know what?
they know them.
The president needs to use executive order on anybody. If you are caught with human part, death sentence within 48 hours. Get the body part of human being. You are going down immediately. Because as a Nigerian, we need iron hand at times. If you are a senator, they find no matter how popular you are. If you are being caught with human part, you are going down within 48 hours. They have to do that. And you see that it's very, they are not, that one will not eradicate everything, but at least 70% it will go down.
President Tinubu knows what to do. Yes.
Thank you, my brother.
Thank you very much, sir. Thank you for your contribution. I really appreciate this. Thank you very much.
You're welcome.
Yes.
Yes, sir.
All right. So, okay. Hello, sir. Please go ahead.
Good afternoon, Lisa.
I salute you.
Let me congratulate all the progressive mind.
You are welcome, sir.
And the progressive youth. I am so much happy for this success today.
Yes.
I congratulate the President, the Federal Republic of Nigeria, and all the youth. I will specifically congratulate all the youth that face the challenge to stand to this time.
Yes.
So, and the way forward now, like what the last caller said, he has expressively talked so much. He has touched some area. The area I wish to contribute on now is the mindset. Is for Nigeria to come back and realize that we have a future, we have a life to live. We should renew our mindset. If we love each other, if we love the country, if people can actually come together to do the right thing, like what, thank God the president said it in his manifesto, that people have to rethink and love the country. We are talking about the rise of pounds, the rise of dollar. What our bankers are doing about it? If you go to to Nigeria Bank today, you will be marveled with what is going on, how they are handling the situation. So if we can have a renewed mindset where people love the progress of the nation, everybody will come together. Talking about the National Assembly purchasing car is not the problem. Let them go and buy it from the local manufacturers. That's my own point.
Of course.
For some, I used to say something that if you are not in the position, you can't sit outside the situation and be judging it. Some people, they have not been empowered, they don't know what politics look like, but they are the internet lawyer, internet judge, giving insight of what is going on. I think if they are there, they can do better than who is there. So if the National Assembly don't want to do anything, let them put the national interest, let them buy local, let them stop buying foreign things. So those are if anybody want to criticize the government, these are the angle I wish them to criticize.
Yes. And we are going to start criticizing the government because now our president is our president now. So we're going to focus on the things that we are seeing. I think what you just mentioned now is what I discussed yesterday. I was saying that the government should show example. We want our own currency to have value. How can you use millions of dollars to go and buy SUVs outside of the country? Which means you are investing our money, our own money that we don't have to another country. Which even those people in that country, they don't use money to buy their cars. They buy it on finance. And look at, we take our own money and go and sponsor them. You understand me? So, oh my God.
And another point I want to mention again, the president has mentioned of the issue of credit and mortgage. If Nigeria that keep borrowing LAPO, keep borrowing grooming, and they did not refund, and the youth will come online, making fun of LAPO, making fun of all this spam pay, that they borrow money, they didn't repay. Are these the people that want to take credit?
But so there's what is called credit report and credit score, sir. That is why we need to have the credit system, of course. I know you know that. So with that credit report, with that credit, if you are already taking credit and then you have not repaid, you will not be able to take another credit because your credit score will be low. So every banks and companies will be mandated to use the credit system. That is how it's done in the UK, every other place in the world.
Yes.
And that is what President Tinubu is talking about. Yes.
And even your platform, what I want you now, you should not sit down after this election now and say it is over. You should please help us to be criticizing in the right way. We will use your platform to talk to the government, to talk to the people. If you love Nigeria, if you are taking the mortgage, if you are taking everything, take it with sincerity. If you are giving opportunity to give loan like this school loan now, if they are going to share it, they will share it with sincerity in their mind. And people should stop writing their millionaire in acquiring government property. So those are the kinds of criticizing or critic that I want people to talk about now. It's not about all this issue of people are buying SUV, people are buying. If they are in that office, when they buy it, if Obi become president today, is it going to continue to use the vehicle is using presently?
All right. Thank you very much. I salute you, sir. Thank you very much for your contribution. Thank you very much, Chief. All right, please, if you want to call now, the line is open. You can call and make your contribution. I've been here for almost 4 hours because I'm gonna end the broadcast soon, so that I will come by again. We are now ready to start our work. I believe that the federal government is ready for the criminals. They say November 5th, they want to burn down Nigeria. They are planning all kinds of things. November 5th. Are they going to wait till November 5th this time around? I believe that the federal government should know what to do. These guys are criminals, They are a bunch of criminals, and they are always looking for what to do. Please, the line is open. I miss calls. If you want to call now, you are free to make your call and your contribution. What do you think? What do you think is the next way forward? What do you think we should focus on? What do you think our president should focus on? Because now it is time. BBC, Nigeria Supreme Court today affirmed the election victory of President Bola Ahmed Tinubu. Okay, before, what were you expecting? is only success all the time, guys. We cannot fail. The city boy is on the throne. When the city boy is on the throne, nobody can bring him down. Yeah, please, can you hear me? Because I can see that either something is wrong. Can you hear me, guys? Yeah, please go ahead. Can you hear me?
I'm hearing you, sir. Long time.
Ah, long time now. Yes, will the city boy defeated all defeatables?
Everybody, I should go and sit down. Just what you do for my excellency.
Yes.
Our president.
The uncommon city boy.
President.
Yes.
Uncommon city boy.
That's
what you mean? Baba can now face what they call government now. Nobody can.
Governance. Yes. Yes.
Just face it. Because help him and give him the good head, and our guys also good head and a long life.
Of course.
All these platform people, they should go and find rest.
If they do anyhow, they see anyhow this time around.
They will see anyhow. They're not the year with now. Where are they? They're very stupid people. Thank God for today.
Yes, sir.
Thank God for today. As I not well reached, I'm in front of my television like watching it like.
Thank you very much. I salute you. Thank you very much. Obi, I salute you, sir. I salute you. Congratulations. Yeah. Well done, sir.
We don't enter. Yes. I don't get too much talk.
Yes.
Let me tell you, Ingo have been caught. 5-man judge.
Yes.
Judge against him.
Kai.
He don't carry his own. Go and Supreme Court today. 7-man panel judge against him. They don't even treat the case. They don't even treat it.
They say it's a waste of time.
They just can't. Yes.
But
they don't even treat the case.
Yes. Yes. I've not even started analyzing it. Yes. Because it means that the lawyers is using his stupidity. No, continue, sir. Continue, sir. Yes.
I don't know whether to call them fake or what.
They are a bunch of criminals, sir. Yes.
Yeah. They do not treat matter. The only matter they remove there is not to shun things, to say, what kind of people are you? We have treated this matter here.
Yes.
Why bringing it again?
Yes.
If not, they will not talk about this matter at all.
Yes. Yes.
Shame to him.
It's a shame. Yeah.
He has spoiled chance of people for more than 30 years. That is almost 50 years. That man is a fool.
Innocent people.
He will account for the money the fraudulently take from people. He will take the money. We must account for the money. Don't worry, anything in life. Because he just entered this case to bring his people so that the people will cool down for the matter. Now
yes.
The matter has finished. They will ask him the money.
Yes. Yes.
Because this man did not pay 180 did not pay the money.
Yes. I'm hearing that some of the Labour Party agents they are still complaining. Yes.
Yes. That's why he could not bring one person to come and witness the court. Because he did not pay.
Wow.
You don't know them. Because if you pay them, you will know them. So look at him, how you replace them. The other case you win in Anambra is because Ikike and the Oba people are fighting.
Yes.
So they just do it that instead of if they will remain in office, they take that power into. That is why he wins that election. Not because he wins.
Yes.
It's because of us.
Please, sir, hold on, sir. Let us. The president is speaking. Let us see what the president is saying.
To have a change of mindset. Let us be positive about our country. Be ready to contribute in all ways possible. There's no promise of El Dorado from day one. We're all in this boat of diversity. A member of the same family, living in the same house, but stay in different rooms. And it is important that we recognize that we have no other country but this one. So, we better be committed to it, not for the sake of our own self-aggrandizement. Our commitment to the values, the creed of dedication, patriotism, and commitment to the value of this country.
That was the president.
That was the president, President Bola Ahmed Tinubu reacts to the Supreme Court
We are going to play it again later. But that was the man that they said did not go to school. That is an insult to our president. They must be fined and punishment. In fact, the president cannot file a case against them. Hello, I salute you.
Hello, Mr. Sima. Good morning.
I salute you. I salute you, sir. Yes.
My brother, I just woke up when I saw you. I said, I hope it has happened, man. When I saw the congratulations stuff, I was like, oh my God, thank God.
I know you guys are just waking up in America. You hear the news.
Yes.
The city boy defeated all defeatable, sir. That's it.
Mr. President cannot breathe. The city boy organization, we cannot breathe. Because the propaganda was just becoming so much.
Oh no.
In fact, they say, I was telling my younger brothers, like I told you, I have an Igbo extraction. My younger brother, they're like, brother, they lie. We are going to, I said, let us see. I thought we all went to school. But I told my younger brother, if our mom was alive, I think I would tell her that we wasted money in training the three of you going to school.
Wow.
We could not read the handwriting on the wall. It was very, very, it is straightforward thing.
Yes.
What has Abuja get to? Are you telling me now that I live in Port Harcourt? If I have to leave Port Harcourt and move to Abuja, I become more special than people that live in Port Harcourt? Or people that live in Akwa Ibom and all that? That is nonsense.
You don't have
What
sense.
is Abuja special? What makes Washington DC special than Texas, where I live, that can determine who becomes the American president? Right? And you went as far as saying this man did not go to school. For crying out loud. Can Tinubu, Obi and Atiku stand and let them speak? And you will tell me that those other two guys are more eloquent than Mr. President? Come on, man. Come on. I mean, I don't even know how this. I don't want to offend you, Mr. Simo. I don't know if they were born in the 90s, but the children of the 90s, I think they need to be
That is why we need to do something about our education system in Nigeria, sir. Yes.
And the history, because
yes.
This children of 90s, this early in the 90s, I think.
The Indomie and the Gen Zs, whether they call themselves Gen Zs or whatever they call themselves, who knows? Yes.
The curriculum needs to be revisited.
Yes.
And I just want to say congratulations to Nigerians.
Congratulations.
And now the president's foot are in the ground, and I promise Nigerians, this guy is going to surprise them.
Oh my God, I know this lady at the back. Wow. Thank you. I know the lady now at the back standing. Oh my God, that is Amaka. Hey, Amaka, what are you doing? Wow, this is wonderful, sir. Congratulations to all of us. I'm so much happy. Oh my God.
It's a joyful day for every one of us who believe in the city boys' agenda, and I know he's not going to disappoint us.
He has never disappointed, sir. Thank you very much, sir. Thank you.
You're welcome, sir.
Wow, this is Amaka. I know Amaka from Nnamdi Azikiwe University. Oh my God, I salute you.
Congratulations, my brother.
Congratulations.
Something on top of my Facebook. Now all these people when they message me underneath, so they support this man.
Oh really?
Your name now, but I say because your name now, but you know see how much they sell for now. I say let them sell for 250. They don't sell now for 70-65 now. People don't die. Make them they sell now for 250 now. Obi where I mean say where I shall be pass out. You hear me so?
Yes.
I shall be pass out so now you go be my president. You don't see the Supreme Court judgment today. Obi, they don't even wait. They don't waste. They don't stay 3 minutes for Obi. They say they don't fit the.
They're not even judge in case. They're not even talk to them. He says he's a fool. Obi! Import and export.
The time when they call you, never come be governor. You fight
fight like this. You don't fight now. You do election, you don't win now. You don't work out. They call you back. They call you back. They say that you win. They won't impeach you again. You say you're not there. You don't work out. They call you back. They say they don't be impeach you. You win second time. They don't give you. They still call you back. So this time around, it's a bit part of it. Now, this is Bola Komo. Go to Facebook, you see me there. This is Bola Komo. I can tell people say I sabi pass Obi. Obi no go be my president because me say I don't be president. You get what I talk?
Yes.
I know fix. I know be president. So why I go come to make Obi my president?
No, sir, to me, sir, to me, eh?
I go go there from my brother wait. From front to fire. From front to fire. What is happening? The guy is having lie. But when they talk, say he's a madman. Madman, they advise him.
They say Obi appeal no even get water. You know, he lack merit, he lack everything, he lack.
I said no, these 2 minutes.
God.
I concur with this. I concur with they say they're not being used as a life. I say the thing and the same thing. But you know these 2 minutes, they don't give me judgment. I come they look in lawyers. And they go back come out and say, see these foolish people. They don't shock these people tire.
So what I wanted to say is that I mean that explains the reason why the Southeast is in a jeopardy today. Are you getting me? Can you reduce the volume of your TV, please? So yeah, I say that explains the reason why the Southeast is in a jeopardy. We are going to talk about this later when I come live again because this is the reason. Because how can you have this kind of lawyers who presented your case and they don't have sense of reasoning? It does not make sense. And for me, I'm still calling on the NBA to design a program because it's not everybody that will be a lawyer. It's not, because they have been disgracing this country for so many long time. Something must change this time around. Look at the issues that is going on in the Southeast. It's unbearable, unbelievable, stupidity, criminality, and they still continue. Even the elders cannot speak up. No, the governors cannot. There is nobody that can call anybody to order in the Southeast. That tells you what is going on. That tells you what is going on. Because if I was in that case, I don't even need to be a lawyer. I would tell Obi, no, we cannot fight this kind of thing. It's stupidity. The judgment is already there. Oh my God.
Just go relax. He just himself. He just put himself for the guy where he don't even get prayer. He just see that platform. He saw the platform. He saw the what do they call them? Now this lady whatever. Now he just jump on top of him. He can't be like say he won't count the work for us. You don't try now. You get 6 million. Before they wait for another time, you don't even get this. You don't even get anything. You say you win election. You see they come appeal out. They do you come they take Nigeria and do you say they appeal election. This gentleman will win the election. That boy when they follow me talk, he say you say you sabi pass this man now. What you did? I say why I take sabi pass. So why I take sabi pass? Why I not be president of Nigeria today now? What you they talk? I said, go sit down, don't follow me talk this thing. He said, because he said today that they sell fuel now, 65. Excuse me, that they sell fuel for 65 naira. He said, so if you know they abroad now. I said, my brother, if they sell at 250, I know tell me they sell at 250.
Abi, you don't tell her how they sell petrol for abroad or fuel for abroad? Abi, the price is it not everywhere? The increase at everything is everywhere.
I am a truck driver. The guy that is talking to you is a truck driver.
Oh.
Every day, when I'm going out like this, every day, it depends on where I'm going. The least I will buy into my truck is $450.
Oh.
The least $450. By the time if I'm picking up because I work in the oil field, by the time I do 2-3 loads, I will say maybe I will need to buy. I go say, okay, make I not buy, make I keep my profit till tomorrow.
Yes.
I go buy another one.
Yes.
So you go the time you say, if you don't work, if Tinubu get there, if we don't work, Tinubu not be God. Now God go talk say,
Now God will talk, say, okay, let there be peace, and it will be so. If Tinubu won't make Nigeria good, if we don't work ourselves, I tell one of my friends, now my classmates for university, the guy na pastor. So he go call me one day, me and we come dey talk. He come talk say, now you talk say make we vote Tinubu. He said we don't vote the Tinubu now. Now you say make we vote Tinubu, we don't vote the Tinubu now. Fuel na 65 naira. Not today, sometimes like 3 weeks ago. Fuel na 65 naira. We no job, no deal. I don't even allow me to finish. I say, what is your contribution to that economy? What is your contribution to Nigeria's economy? If you are not taking from people, you take from people. You go sit down for somewhere. You go say, when they come do offering. Now you take. What do you contribute? When we say people feel benefit from in that country, just tell me. The guy just Baba Komo. I said, talk now. Every one of you will say Nigeria no progress, no progress. You don't go even do anything. You go to your house. You don't go find something to do. I get one boy when I know the boy. When I know the boy, anytime when I come UBA, now security for UBA. Trust me. Now so I go they call me. Now so I call me friend. Sometimes the contact is across. I know the UBA again though. I the NYSC now. Some person don't help me for NYC. They give them Okada. For evening, go take the Okada and go make a little money. Sometimes you just tell me, for messenger. Once I just call my video. I say, why they call me now? He said, bro, make an overs. He said, he just want make I see him farm. He said, make I see him farm. If you see the farm, if you see the way the farm was too much. Hello, are you sitting there with me?
Yeah, I'm here with you. Just cut the story short because we need to pick up another call. My question I want to ask you now is, has Obi and Atiku congratulated the president, sir?
No, I've not seen it.
Okay.
I'm watching the TV now. I've not seen it.
Okay. All right.
I'm not sure if they're gonna do that.
So we should know that they are the enemies of the country. They are part of the enemy because they are Obi is from a region where they have been bringing criminality and trouble to this country. Obi, and you see have the temerity to say he wants to be the president of the country. When they are from the foundation of the country, they have always been the one bringing criminality and bringing problem in the country. He has not settled the problem of their brothers. Every day they are talking rubbish, and at the same time he still wants to be the president. Are we so stupid?
It's talking rubbish. Are we so stupid, my brother? Are we so stupid, my brother? Now so we go ask them. Yeah, it has come to an end today. That's it. Thank you for listening to me, my brother.
Thank you very much for your contribution.
Just continue doing this, so I'll be part of you now. Continue doing this.
We are winning, sir. We are winning, sir.
We are winning. That's my number for you. Continue doing it. If there's anything for us to take support you, continue doing it. Let me know.
We are winning, sir.
Contact me. Yeah,
all right. Thank you very much. I appreciate you. Thank you. Hello, sir. I salute you. Hello, sir. I salute you. Can you hear me? We can't hear you. We can't hear you. Please check your volume as you are calling us. We can't hear you. Please, if you are calling us, we can't hear you. Can you check your volume and call us back? We have defeated all defeatables. That's it. Hello, I salute you. Welcome. We are live and direct. Yes.
Yeah, congratulations, my brother.
Congratulations.
I don't have time to get my phone. When I got up this morning, when I first called you, I don't even know you're online, but I just picked my phone. Let me call you.
Yeah.
This was so powerful. No, great news, we know we just come for here.
Yes.
Congratulations, my brother. Congratulations to all Nigerians that believe in our president.
Yes. Yes.
And I want to contribution to the abuse. So first of all, I don't go by my fear. You know that celebration day. We don't allow them wait. Like always say,
it's finished.
No more. There's no excuses anymore. But my own contribution to do, and I want to hear what is to do. Baba Tinubu president this year, and is still spending one budget. We all know that. As some people
from January 2024, yes, the new budget will go in place. Yes.
year, the US will be expecting the new OPR. First of all, loans for students will be released. That budget will include private businesses. Government are going to put money into manufacturing. A lot of things. People need jobs. They are ready to work in the warehouse. There's not a warehouse in Nigeria. No, people they are bringing investors in. That's where we will work for here. So everything will kick on. Baba Jagaba, then now will finally kick on next year, and we will now see how intelligent men run government. Because to God be the glory. I don't know if other people else, right? 2008, I left Nigeria, and that was the first time I entered PRC for Lagos. I so much love my brother. That's part one. I came to this country, and I came with papers, so glory be to go. I don't have time to enter train or public buses. I started driving. But to Nigerians, to the enter train for Nigeria is a privilege for them. Baba said, this is Lagos vision, but it's from 20 years vision, right? And it finally comes to pass. By God's grace, this is my mayor and you that we started this, right? Now we go see better Nigeria. Now we go see better Nigeria. These people rule for 16 years, non-stop. All Africa, we started coming to Nigeria. Most of the people, they very good traveling. Because one, job position. That's what we make it in Nigeria.
All right, sir.
God bless you. Congratulations, you are so happy.
Thank you very. We'll still talk. We'll still talk in the evening, sir. Yeah.
Now, my brother, God bless you.
All right.
I don't know if you're online for this, but bye-bye.
Bye, sir. Thank you very much. I don't know, some other people, I missed other people's call. Hello, I salute you.
Hello, Isima.
I salute you.
Congratulations to the city.
Congratulations. The city boy defeated all defeatables.
Oh, yes. Oh, yes. I mean, where is the Kenneth Okonkwo?
Oh, let me put his face. I capture his face somewhere.
I thought he will say, my lord, let me explain. TV now will be talking as if they put hot water in his mouth.
No, we go here. He go talk now. No worry.
On media now will be talking. So he can't talk now. I expect him to talk as the legal position of Obi. He's supposed to stand up so that he will show himself in court that yes, he's in court. That's stupid, not the wood actor.
That's the kind of case that they file. Like, it's a shameful thing.
It is better. He better write letter to the Prime Minister in Finland to employ him. So that he will be able to go ahead there for the referendum in Finland. Obviously, he has failed with Obi now. So that he can be able to move to Finland and go and help
Yes. He will move soon.
Yeah. So we are expecting, though you said Obi did not come to court. I did not like what you said. Obi was on his way now. Anambra. It's because of the hold up. I don't like what you are talking about. Now Obi is in Abuja now because it's over.
So yes. Obi is now the president.
Kind of traffic that Obi on the way. I don't like it at all. We have to petition quickly for that. What kind of nonsense is that? Obi is coming from Anambra, all the way from Anambra. And the hold up that Obi now. By the time Obi gets to Abuja, because it's over.
Oh no.
They have to do that court again. Because Obi has to be president.
Oh no.
Obi must be in the court.
Oh no.
You see how God put them to shame. You said Obi will disgrace 3 times.
Yes.
And that's come to pass. This is just the beginning of Obi downfall. Obi is finished. I expect Obi girlfriend Aisha to be in Supreme Court. I just see them.
That one not even talk anything.
I just see Aisha. I just see her find Supreme Court today. Those stupid idiots. It's only on social media they have mouth.
Yes, now.
To run their propaganda to talk.
Yes.
Even
the court, even the Supreme Court mentioned the case that they are doing social media trial. which for me, I think is a signal to the president to do something about, because we cannot continue this way. Yes.
Now everything is over. It is time for president sanction them to deal with any propaganda about debt. Any debt.
That's it.
We start yours first. Whether you are abroad or you are in Nigeria, all of them they must be debt. Thank you very much, my brother. God bless you.
Amen. Bless you too.
I'm with you on the program.
Thank you very much. The program soon. Anyways, thank you very much. I salute you. We have been here for 4 hours, as you can see. Thank you very much for your prayers. You should well with all of us, all Nigerians, and they will have a reason to. Are you getting me now? All Nigerians will have the reason to enjoy. Just like now, we have defeated all defeatables, even in the court today. Nigerians will also have reasons to celebrate. Are you getting me now? Because when the time of celebration comes, most Nigerians will not remember what some of those people that have been running propaganda against the president, they will not remember what they have been saying, because very, very soon, everybody will, because President Tinubu, we know him, is a man of integrity, he has the experience, he has been doing it before. Are you getting me? That is not happy to go and slay. Are you getting me now? I'm telling you. You understand me? Somebody say, if you have the fear of God and conscience, you will judge right. If you have the fear of God, you are stupid. You people have the fear of God and you are killing your brothers and sisters in the southeast in the name of Biafra. Did you say anything about it? You are stupid. You are criminal. It is people that don't know you as criminal. If I'm given the opportunity, I will deal with all these criminals. I know them. You understand me? Your brothers are dying every day. We saw the way people are doing it. Taking guns and bullets, contributing money for IPOP terrorist organization, IPONG, ESN criminals, celebrating criminality everywhere, and you are telling us about God. Look at all of you. Oh my God. Let me don't go there now, because I don't want to start another conversation. Are you getting me now? We are going to come back later, and we are going to be looking at the things that all Obi and can you imagine how people came together to fail? Obi and Atiku, they came together and they failed. Hey, what a terrible situation. I refuse to be part of failure. I can never be failure in my lifetime. You understand me? Because we are kings and queens and we have overcome the world. How can I come together and be a failure? Obi and Atiku came together and they failed. They came together to run a propaganda against the president that won election, and they still failed. It's a shame. Now all of them they are waiting. They are in a meeting. They are in a competition. They don't know when to congratulate the president. They are in a competition to know when to congratulate the president. I mean, bunch of criminals. I want the federal government to take note, which I'm going to come back. November 5th, oh no, before November 5th, they say that they want to burn down the country. They are planning criminality, all of them. They say they want to burn down the country. They want to come out on the street. They want to do, whether in a revolution they talk, whether I don't even know which revolution is that. I've seen these people for the first time talking rubbish. Are you getting me now? So the federal government should also be alert, because these criminals, they are planning all kinds of things. You understand me? The governors in various states should take note, take note of what we are saying. You understand me? We need our security system to be in place because of these criminals. Anybody you see on the street, these guys are criminals. These guys are a bunch of criminals. They are not for the good of the country. They never wanted to do anything for the good of the country. Anybody on the street doing useless protests or anything, they must be dealt with as criminals, because these guys are criminals. We know them. They are a bunch of criminals. They don't want the progress of the country, and we want our government to be serious this time around and to change everything and to make us to be happy to the Nigerians. That's all I have to say, guys. Today was a wonderful day, and I'm so much happy. We continue to pray for our president for knowledge and understanding. Of course, I believe now our president can be focused, and anybody that do anyhow should be dealt with anyhow. Are you getting me now? Our president will be able to focus. We pray for wisdom and understanding. Everything that he needs to work together with the people that are ready to work with him, to make sure that this country move forward. That's our prayer, guys. We pray for good health, more wisdom, knowledge, and understanding in everything that our president is doing this time around. And we pray for all the patriotic Nigerians, of course, the City Boy family, and all of us to be strong and healthy as well, to be part of this success and to witness Nigeria, because we know that President Tinubu is bringing Nigeria back on track. That's our prayers, guys. Of course, you know my name. My name is Akbarawa Nsima, the first son of Idu. I'm from Akwa Ibom. Our job is to make sure that we continue to fight in order to protect and to defend our land. So now we are going to start our job. Please go to the website www.thecityboymovement.org. The City Boy, I'm going to put it on the screen, www.thecityboymovement.org. Go there, you will see the volunteer application. Please, if you want to participate, every state, every local government, we need volunteers, and we are going to pay the volunteers. So please join us in what we are going to do. It's going to be a wonderful one, and you'll be happy that you'll be part of it. Trust me. This time around, it is time, and we cannot fail. So please join us, the City Boy Movement. Go there, and you'll be able to be part of it. We need people that is on ground, because this is a grassroots action. Every local government, every state, we need to begin to bring the report, and we need to begin to take action, because this is very, very necessary for our country to move forward, guys. So that is all I have to say, guys. May God bless you. We are going to come back again later today, hopefully by the special grace of God. May God bless all of you. May God bless our president, His Excellency, Asiwaju Bola Ahmed Tinubu, and may God bless the Federal Republic of Nigeria, guys. Stay blessed until I come your way next time. Bye for now.